Good afternoon, everyone. Welcome to the final round of the 5th BIAC International Inter-University Arbitration Contest 2024. I'm Sanjita Sona, Assistant Counsel of BIAC, and I have the honor to facilitate the round of this evening. Dear all, BIAC had launched Inter-University Arbitration Contest in 2020 for students of law of Bangladeshi students. However, from 2021, the contest was more board-based with participation by universities beyond the borders of Bangladesh. This year, BIAC is hosting the BIAC International Inter-University Arbitration Contest for the 5th consecutive year. This year, 8 leading universities from home and abroad are taking part in this contest, which are Sonargaon University, Bangladesh, London College of Legal Studies, South Bangladesh, Kathmandu University School of Law, Nepal, V Academy, Bangladesh, Dhaka International University, Bangladesh, University of Asia Pacific, Bangladesh, Bahria University, Pakistan, and lastly, Khyber Law College, University of Peshawar, Pakistan. Now, we are in the final session of where London College of Legal Studies, South Bangladesh is competing as claimant against the team of Kathmandu University School of Law, Nepal as respondent. Before we move on to the main contest, it is my pleasure to introduce the arbitration tribunal and all the participants.
Yeah,
Now, I will introduce all to our today's arbitration tribunal. Everyone, it is my distinct honor to introduce the chairperson of the arbitration tribunal for the 5th BIAC International Inter-University Arbitration Contest 2024, Justice Abdul Rahman Sir. Sir is a former justice of the High Court Division of the Supreme Court of Bangladesh, where he served with distinction from 2003 to 2018, delivering over 7,000 judgments. He is currently a senior advocate of the Appellate Division and a highly respected international commercial arbitrator. He holds law degrees from University of Dhaka, the University of London, from the University of Dublin, California, and is a barrister at law from Lincoln's Inn, UK. He leads Rahman Law Associates and Company in Dhaka. Further, Sir is widely regarded as a thought leader in arbitration. We are truly privileged to have him presiding over this competition. Then, it is our pleasure to introduce one of the distinguished members of the arbitration tribunal for today's final round, Mr. Mohammad Farooq Rahman. Sir is the head of chambers at Rahman's Chambers and serves as the divisional head for dispute resolution, shipping and international matters of the Appellate Division of the Supreme Court of Bangladesh. He brings with him legal expertise for both locally and internationally. He is a fellow of the Hong Kong Institute of Arbitrators, a member of the Singapore Institute of Arbitrators, and the Chartered Institute of Arbitrators. He also serves as a member of the ICC Commission on Arbitration and ADR in Paris. Sir is a panel arbitrator with SCMA, SCIA, and CERCO, a member of the New York State Bar Association, and a CCR accredited mediator. His both experience in arbitration and mediation, coupled with a strong international presence, makes him part of this competition. Now, I have distinct honor to introduce our announced distinguished member of the arbitration tribunal for the contest, Mr. M.D. Abul Khan. Mr. Sir is a former senior district and session judge, bringing with him a wealth of judicial experience from a long and respected career in Bangladesh judiciary. He is an advocate of the High Court Division of the Supreme Court of Bangladesh, chambers at United Law Chamber. Judicial background. Sir is also a practicing arbitrator involved in resolving commercial disputes through arbitration. His common expertise in adjudication and alternative disputation serves him an invaluable part of this competition as well. Now, I will introduce with all our today's participants. From the London College of Legal Studies, Bangladesh, we have 6 participants: Nafisa Binte Borhan, Zohra Mehrab Kader, MD Naim Haidar, Maishata Tanzim, M. Asif Yusuf, and lastly, Kumkum Menzabin. From the Kathmandu University School of Law, Nepal, we have 6 participants: Alisha Tripati, Pushpika Thapa, Sangham Paudel, Siddharthi Gimri, and Smiti Sapkota, and lastly, Divisha Karki. Now, I'd like to warmly invite our CEO, Sir, K. Rahman, Chief Executive Officer of the Bangladesh International Arbitration Center BIAC, to say a few words and officially declare the opening of the 5th BIAC International Inter-University Arbitration Contest 2024. Following his remarks, he will kindly give the floor to the honorable members of the Arbitration Tribunal to begin today's proceeding. Sir, the floor is yours.
Sure. Thank you, Sanjida. It is my privilege to welcome the distinguished panel, particularly the chair of the panel today is Justice Abdur Rahman, and along with him we have the contestants from the London College of Legal Studies, South Bangladesh versus Kathmandu University School of Law, Nepal. And dear contestants, I know that you have come through a different rounds of debates and your arguments, and congratulations in advance that you have come up to this stage. And BIAC is pleased to host you to this final round. And with these few words, I would rather hand over the session to our panel chair, Justice Abdur Rahman.
Okay, assalamu alaikum. I want to know first, how much time is allocated to each of the team?
Sir, each team has 60 minutes.
Each team has 60 minutes. So 1 hour and 1 hour, and rest 1 hour. So 3 hours. Right?
Yes, sir.
Yeah. So let us start. Yes, the claimants team. The claimants team is requested to start.
Further, I'll be counting the time as well. I will give a signal before 1 minute and when the time is over. So the claimant team will start.
Yeah. Yes, the claimants team, take the floor.
May it please the Arbitration Tribunal, my name is Zahra Mera Qadir and I will be acting as the opening counsel for the claimant. Before I start, our team is missing one member, so can one of the members play a dual role of one of the witnesses?
The scheduled member is missing, not he is coming.
No, she is not here due to unavoidable
circumstances. You are praying for an alternative member.
No, we are asking that whether one of our members can play a dual role in this.
Yes, but that will not. And why not you engage another member?
Can we do that?
You can engage another member, no problem. But if you act dual, that will not be convenient for the marking. Yes.
Thank you so much. My team appears on behalf of the claimant in the matter of 𝐕𝐧𝐿ife Limited versus 𝐁𝐈𝐀𝐋 Indonesia. As the opening counsel, I will be giving the opening statement. Ms. Nafisa Binte Borhan will be conducting the examinations in chief of 2 of the witnesses, and Mr. Naim Haider will be conducting the cross-examinations of all of the respondents' witnesses. Lastly, Mr. Asif Yusuf will be giving the closing arguments and submissions for the claim. Now, with the Honorable Tribunal's permission, the Council would like to give the opening statement for the claim.
Yes, but before the Tribunal permission is given, I welcome the other 2 learned arbitrators, the very celebrated legal professions, Mr. Farooq Rahman and Mr. Abul Hussain. Yes, so though I'm presiding over the tribunal, but those members are also to be considered in your submission, right? So you proceed.
Thank you. This arbitration arises out of a dispute following the termination of a supply contract by the respondent, 𝐁𝐈𝐀𝐋 Indonesia. Between 2021 and 2024, 𝐕𝐧𝐿ife cakes containing dark chocolate that had been sadly accepted and recognized internationally at that time. The claimant acted in accordance with the contract and industry norms, delivering goods that were accepted by the respondent without any objection for over a period of nearly 3 years. It was only after our televised expose in January 2024 that revealed fraud within the Ghana certification system that the respondent halted deliveries, withheld payment, and eventually terminated the contract. Notably, the claimant conducted its own internal investigation, self-reported their findings, and attempted to resolve the issue in good faith. In light of these facts, the claimant will raise and address three key issues here. The first issue is that no damages are payable to the respondent. The claimant relies on Section 73 of the Contract Act 1872, which limits damages and to losses that naturally arise from a breach and excludes remote or indirect losses. This principle is rooted in the case of Hadley versus Baxendale and also incorporates the duty to mitigate as confirmed in the case of Pananal versus Dugat. The law of contract recognizes three types of interest for damages: expectation, reliance, and restitution, and none of those are applicable in this case. The respondent's losses were not a direct result of the claimant's conduct. The 600,000 cakes were delivered and could be sold as there were no health issues involved, and so any loss that stems from the respondent's voluntary decision not to sell them and not the non-conformity of the cakes itself. This makes their losses too remote to justify the damages. Even if the code of conduct was violated, it would be unreasonable for the respondent to incur heavy losses intentionally because the claimant had acted in good faith, prompted investigation, and did not find any health risks involved. And thus, there were also no consumer or regulatory complaints. Thus, the losses were not foreseeable, and thus they break the chain of causation. Moreover, the respondent failed to mitigate their own losses. Under Articles 18 and 20 of the contract, they were obliged to do so, even if that conflicted with its code of conduct. Under the delivery duty paid arrangement, once the goods reached the buyer, risk shifted to the respondent, reinforcing their responsibility to reduce the harm. The respondent also breached the confidentiality by implying that there is a supply relationship breakdown, which violated Article 19 of the contract. This renders them liable to pay liquidated damages of $500,000. As for the restitutionary interest, the claimant only earned $0.3 per cake, totaling up to $180,000 in profit. Even if the restitution was awarded, it would be more than the offset by the liquidated damage, leaving the respondent owing up to $320,000. The second issue that we bring is that the claimant has acted in good faith. Section 37, subsection 3 and subsection 4 of the Sale of Goods Act 1930 allows rejection of mixed goods but is subject to special agreements. Here, the agreement required ethically sourced cocoa, which the claimant under the Ghana certified scheme, which was trusted at that time, have followed. The industry reliance on certification is protected under Articles 8 and 9 of the CISG, and no fraud was known during contracting or performing their obligations. Further, Article 7, Subarticle 1 of the CISG and Article 1.7 of the Unit Joint require good faith. Here, the claimant has acted promptly upon the discovery of these events and they have shown transparency. Under Article 17 of the Contract Act 1872, fraud requires intent to deceive. The claimant had no knowledge of certification issues before 19 January 2024. They made no false claims and they also voluntarily disclosed the problem in February 2024, showing honesty and transparency. The courts in Paresh Chandra Bhomik and Kornufuli Paper Mills stated that clear fraud is required in order to avoid a contract. The respondent accepted the deliveries with no issues for over 2 years and thus confirming dissatisfaction. The claimant only learned about the issue after exposed in January 2024, and the respondent quickly fulfilling the good faith duties under CISG and the unit right principles. The next issue is that the respondents must pay for the delivered goods and interest. Articles 16.1 to 16.2 of this agreement obliges the respondent to pay $2.4 per cake, totaling up to $14,000 for 600,000 cakes that were delivered. The claimant delivered those goods and the respondent accepted them without any objection, triggering the payment due within 60 days. As held in the case of Nija versus 𝐷𝐴 Spain, accepting goods without timely objection bars later non-conformity claims. Further, under Section 55 and Section 73 of the Bangladesh Contract Act 1872 and Article 53 of the CISG, failure to pay for accepted goods is a breach. Further, in the case of Sonali Bank versus MD Abdul Manan, the seller was entitled to pay the full contract price for breach of it. The respondent cites media reports, not contractual evidence, and gave no timely notice for non-conformity as required by CISG Article 39, Subarticle 1 and Subarticle 2. Article 62 of the CISG allows the seller to demand payment unless pursuing inconsistent remedies. Here, the claimant consistently sought remedies, and moreover, Article 3.3 bars unilateral price changes, and the respondent's attempted set-off has no contract.
Excuse me. Why you're submitting the arguments? You're on opening statement. We want to know the facts of the case. This is not the time for argument. You're not to cite the laws and other things. Only the factual aspect you are to submit, because you are on the opening statement, right? Yeah.
Mr. Arbitrator, I was supposed to give the opening statement along with the arguments, and then the other counsels would give the closing arguments, and they would perform the examinations in chief and the cross-examination.
Argument before the examination of the witness, no argument can be heard.
Okay, thank you.
Yeah.
So in today's claim, the claimant would seek an interest on late payments, and as affirmed by our claims. And so with this, with the Honorable Tribunal's permission, I would like to give the floor to Ms. Nafisa Binta Borhan to perform the examination.
Sure.
Good afternoon, Mr. Arbitrator. I hope I'm audible.
Yeah, you are audible.
With the permission of the Honorable Tribunal, I, Nafisa Binta Borhan, the counsel on the claimant's side, would like to start the examination in chief, where the first witness would be Mr. Nazmul Puri. Can the counsel proceed, sir?
Sure.
Please state your full name and your position at Sweet Delights Limited. Am I audible? Hello?
Masha is the witness. Are you the witness?
Yes.
You are witness, yes. So
Hello,
you are good. You are witness on behalf of the claimant.
Yes, yes.
Yes, yes.
Much obliged. Yes.
Nafisa, what is name? Full name?
Sir, the full name of the witness you are asking?
Yeah, I'm asking the full name of the witness.
My name is Najmul Kareem. I am the Chief Operating Officer at Sweet Delights Limited.
1 minute. You are Najmul Kareem. Yeah. CEO.
Yes.
Sweet Delight. Sweet Delight.
COO.
COO. Sweet Delight. Yes. Yes, go on to examination.
Sir, may the counsel proceed?
Yeah.
Much obliged, sir. Mr. Nazmul Puri, how long have you been in this position, and what are your primary responsibilities?
I have held this position for over 5 years. My responsibilities include overseeing day-to-day operations, contract negotiations, and ensuring compliance with client requirements. I also take active role in negotiating major commercial contracts.
Were you involved in the negotiation and signing of the exclusive supply agreement with Nusantara Cakes Indonesia on April 7, 2021? If so, can you briefly describe your role?
Yes, I did the negotiation process on behalf of Sweet Delights. I led our teams to review the tender documents, ensured alignment with our production capabilities, and finalized the contract.
Can you describe the terms of the agreement regarding the delivery of dark chocolate compound cakes, including the quantity, specifications, and payment terms?
The contract required us to deliver 20,000 units daily, Monday to Friday, with flexibility to adjust between 10,000 to 30,000 units. The cakes were to weigh 120 grams, measure 3 inches in diameter, and be made with ethically sourced cocoa. Payment was due 60 days post-delivery at USD 2.4 per unit.
Did Sweet Delights Limited fulfill its obligation under the agreement by delivering 600,000 cakes from 1st May 2021 to 27th January 2024?
Yes, we fully delivered the agreed quantity during that period without any defaults in volume, quality, or schedule.
Can you describe the internal investigation you conducted, including its timeline and findings?
Between January 28 and February 10, we worked intensively with our procurement and compliance team to audit all cocoa sourcing records. We traced supply chain and reviewed certification documents and contracted with a third party. We found that a portion of our cocoa, while certified, originated from Ghana. On February 10, we disclosed this to the respondent and clarified that the certifications were obtained in good faith.
Based on your investigation, did the use of cocoa from Ghana constitute a fundamental breach of the agreement? Why or why not?
The cocoa was procured in good faith and accompanied by certifications that at the time of the purchase were valid and recognized in the industry. The subsequent revelation that those certificates may have been issued fraudulently does not amount to a fundamental breach on our part, as we neither knew or could reasonably have known of the underlying fraud. We met our contractual obligations as far as was possible within the industry's standard verification framework. If any breach, it was totally something beyond our control and knowledge.
Were all cocoa batches certified at the time of procurement? And did Sweet Delights Limited have any reason to doubt the validity of these certifications before the expose?
Yes, every batch was accompanied by documentation attesting to ethical sourcing and sustainability. Prior to the expose, there were no red flags or warning suggesting that the Ghanaian certification process was compromised. Like many other global companies, we relied on what were then widely accepted certifications.
Has Nusantara Cakes Indonesia paid for the 600,000 cakes delivered? If not, what is the total amount owed and when was it due?
No, they have not paid. The total owed is $1,440,000 US. Payments were due within 60 days post-delivery, meaning they are now overdue, subsequently overdue.
During this period, did Nusantara Cakes Indonesia raise any concerns or objections regarding the quantity, quality, or timeliness of the deliveries?
No, we have received no formal complaints or written objections regarding quality, quantity, or timeliness during the entire delivery period, even though we maintained open communication within the procurement team of the respondent. Their silence over continuous deliveries told that they were satisfied.
When did you first become aware of the televised expose regarding fraud in Ghana's Sustainable Agriculture Certification Scheme?
I became aware of it on the evening of January 19, 2024. Time I had encountered any suggestions that Ghana's sustainability certifications might be compromised.
How did Nusantara Cakes Indonesia respond to this news and what communication did you receive from them on 27th January 2024?
They emailed us stating that they were suspending deliveries and payments due to concerns over cocoa origin and requested clarification whether any portion of our supply originated from Ghana.
What was your response to their concerns on 27th January 2024?
We immediately took their concerns seriously and confirmed that we had no reason to believe that our cocoa supply was compromised, but promised to investigate thoroughly and revert with the findings.
Well, that would be all. Thank you, Honorable Tribunal, for giving me the
Yeah.
time.
As cross-examination,
With the prior permission of the Arbitral Tribunal, I, Siddharth Kimire, would counsel for the respondent would like to start the cross-examination of the first witness.
Yeah, yeah.
Shall I begin?
Sure.
you.
What is your name?
𝐷𝐎𝐵𝐺𝐻, sir.
Siddharth Vishnu. Yes.
Yes, sir. Thank you, sir. So, Mr. Karim, can you briefly explain what your role as Chief Operating Officer is at Sweet Delights Limited?
My responsibilities include overseeing day-to-day operations, contract negotiations, and ensuring compliance with client requirements.
So, Mr. Karim, as a COO overseeing procurement and contract compliance, you knew the agreement required ethically sourced cocoa and sustainability standards were essential, correct?
Yes, that's correct.
Okay. So, wouldn't you agree that the respondent acted appropriately by suspending deliveries and payments on 27 January to allow for an investigation and seek clarification from your team?
No, that was not justified.
But Mr. Karim, you admitted non-compliance on February 10, so respondent only terminated after that, correct?
No, respondent terminated before I contracted them. So they suspended. No, this is suspended their part of the obligations on 27th of January, and we started our internal investigations from 28 January to 10th February.
But Mr. Karim, would you agree that there is a difference between a suspension and a formal termination of the contract?
Yes, I'm sorry.
And would you agree that there is the right of the respondent itself to seek clarification from your team, right?
Yes, and we complied with that. We provided them with the clarifications as promptly as possible.
So you agree that the respondent only terminated after that, after
Yes.
seeking clarifications. Okay.
Yes.
So wouldn't you agree that the cocoa from a discredited source could seriously damage respondent's reputation?
The reputation. Could you please repeat the question?
Okay, I would rephrase it. Mr. Karim, we knew that at Dhaka's Asian Food Fair, the team from the claimant provided a brief and a very good presentation regarding their products. But after learning about that, the respondent gave the contract to the claimant itself. Is that correct?
Pardon me, could you repeat the last line, please?
Okay. So you knew that you all gave an extensive and a good presentation at Asian Food Fair at Dhaka about sustainability standards, right?
That's correct.
And after that, only the respondents gave their contract based on the sustainability standards, right?
Yeah, based on the tender. Yes, that's correct.
So wouldn't you agree that the cocoa from a discredited source, which later you delivered, could seriously damage respondents' reputation?
Well, we did not deliver any from any discredited source because at the time of the procurement, the certifications were valid. Okay, and it was we delivered the certified product and what we contracted for.
But isn't it your responsibility to check whether the certifications are correct or not according to the sustainability standards?
Yes, yes, that's my responsibility, and we did check that once there were objections raised. Before that, for 3 to 4 years, we have been conducting this business, and there has been no complaints or any issues raised. So it is very reasonable for us to depend on a internationally recognized certificate and documentation. Our responsibilities are limited to verify the documentations, which we did. And once there were issues raised, we acted promptly and with good faith. We did not delay anything or try to deny our responsibility or nothing.
Okay, Mr. Karim. But would you agree that there was a lapse of judgment or lapse of lapse of work from your part regarding the certification's authenticity, right? In the later
No.
part of the contract.
No.
Then
I completely
No,
deny that.
this question will not go. This opinion, this question will not go. Yes,
okay,
next.
okay, Mr. Arbitrator. So if many cakes had non-compliant cocoa, shouldn't that affect respondents' right under the contract?
Many what?
There were many cakes that were from a discredited source or that was non-compliant. Shouldn't that affect respondents' right under the contract?
The forgery was created from a third-party source, and it was not done by us or us as a claimant, because we fulfilled our obligations, and our obligations does not go beyond checking the validations of the certification. And 3 years the business transactions proceeded, and there was no complaints. So of course we were not reasonably ought to go and investigate something into the matter.
But
Okay, I have one question. Could you explain the certification process? Because normally it is an international organization. Few international organizations do such certification of sustainability, and they have a global, headquarters, and also they have local, the kind of their support organization also. So who issued the certificate? Is the supplier, from where you're procuring, or the other organization? And who made the falsity information? How it happened? Like, is the supplier provided false information to the certifying authority, or
Sir, the contract was regulated by international laws. So the documentation was certified by those laws.
the fraud means that there is a false information. So could you explain that who gave false information to whom? There is a production, when the sustainability certificate issued, it start from the very beginning of the production cycle. Okay, so they have to what kind of worker is working.
Sir, the source of the cocoa was Ghana, and they created a widespread forgery, which was new to all the buyers and suppliers and everyone. So they were the third party, and this report about their forgery was published in the TV.
Yeah, but you have been dealing with them for so long, and then why you haven't done the inspection earlier, and why you had to wait for a TV news or a complaint from a customer?
Sir, I did not foresee any breach happening because we had followed proper procedures, obtained valid certification, and had no reason to doubt them. The idea that a varied supply chain could suddenly be exposed as fraudulent was something not I or most industry professionals could reasonably foresee.
But it's a sales of good contract. Okay, it's very similar to strict liability. Result-based contract. Okay, so you'll have to kind of compliance is like 100%, even if whether you're in good faith or not, that may not have much of an relevance here. So, if there's a fraud, then
sir, at the time of the procurement, all cocoa sourced had valid sustainability certifications from recognized bodies. Given that, I did not foresee any fraudulent incident occurring, and our expectation was compliant.
Okay, thank you.
Sir, can I question?
Yeah, we proceed on.
Okay, so Mr. Karim, as the CEO of a party, the person you're working as an overseer for the procurement as well, right?
Yes.
So it's a general knowledge that procurement process involves seeing or involves correcting each and every element of the contract or of the goods that you're selling, right?
Yes.
1 minute
So
left.
wasn't it your duty to ensure cocoa met contract standards?
Non-compliance after you conducted an inspection in the whole matter? Is there any admission regarding your non-compliance at a particular period? At a particular period?
No, no, sir. We informed them that there were some of the batches of our cocoa yet certified, but was from the Ghana sources. But we did not accept that we are not compliant.
What is the outcome? What is the outcome of your investigation? Your investigation, there is an outcome where you have said that there is some non-compliance at a particular period of time. Is there any admission regarding such a non-compliance?
No, sir.
No, it's all right. Go on. Yes, Kasim, go on.
Okay, sir. So, Mr. Karim, given your role and the contract terms, wouldn't any sourcing failure be Sweet Delight's responsibility, not the respondents?
Before we could take any responsibility, the respondents terminated all the, they acted abruptly. So we could not initiate any negotiations, even though we have tried to sit for negotiations, but the respondents did not comply.
But you agree, right, that the respondents first suspended the contract and not directly terminated it. Suspensions regarding checking of what had happened or what lapse had happened at the procurement process.
The respondents suspended all their transactions on 27th January, and later on, they did not continue to pay us for this for the amount of cakes that we have delivered already.
But you did say that at February 10, the respondents, after you admitted about the non-compliance, respondents then after terminated, right?
No, we did not admit to non-compliance. We acknowledged that the cocoa originated from Ghana.
Yes, that's a admission about a non-compliance, right?
And small amount of cocoa originated from Ghana, not even the whole supply.
Yes, Mr. Karim, but even a small amount would directly affect the respondent's reputation in the market, right?
No, how?
But
No.
small amount is also a substantial amount, almost 600,000 cakes. That's not even a small amount, Mr. Karim.
The entire 6,000 cakes were not totally made with the cocoa originated from the Ghana, of course. So you cannot say that. And moreover, the respondent failed to mitigate the situation by not selling the cake. It was on them. It was not on part of us.
It considers a lapse on your part, right?
What kind of lapse?
The agreement that was made.
What kind of agreement? The agreement that we have to comply to your sustainability of the cocoa?
Yes, Mr. Karim, because you have signed the code of conduct.
Yes, we had signed a code of conduct that we are going to supply you sustainability cocoa that is certified. And we did that because now we have acknowledged that the cocoa that small amount of cocoa originated from Ghana. And when we agreed that it originated from Ghana, when we delivered you the cakes, it was already certified. It was not yet published as non-certified. And moreover, the TV publication, which was published on the TV, it did not specify any specific things, what the forgery was about, or what was it, and the details about it. So,
okay, yes. Mr. Karim, but as the arbitration tribunal also asked you earlier, even a small amount of certification requires international certification and a standard. That standard did have a lapse, right?
We wanted to negotiate and sit about it, which the respondent did not. They abruptly terminated.
But the respondent was involved in a mediation.
They were.
Respondent's time is over.
Thank you, ma'am.
Yes, your time is over. Yes, cross-examination is stopped. Next.
Honorable Tribunal, may I begin? The
Yeah,
opening
sure.
from respondent side.
From respondent side, yes. You have to start with the general statement, opening statement.
Thank you, arbitrator. Contracts anchor commerce when principals are diluted.
Disclose your identity.
Sure, arbitrator, I will be doing that. Honorable members of the tribunal, it is my honor to appear before you today as counsel for the respondent Nasandra Cakes Indonesia.
You are Pushpika.
I am Pushpika Thapa.
Honorable Tribunal, am I audible?
Yeah, you are audible.
Apologies for any inconvenience caused, but Honorable Arbitrator, we have another witness that we wish.
That has not been said that you have another witness. You have to say, I have asked her what to do. You have not said anything.
Oh, apologies for any inconvenience caused, but
Yes.
from our side, we thought that any document or any procedure have
all the documents have to be submitted by the witness. Have you submitted that?
We have submitted that.
Mr. Nazmul Karim has not submitted any document.
We did submit a witness statement of Ms. Aisha Fariha. Mr. Honorable.
So now what is your prayer? What is your prayer? For the second witness. You are praying for second witness. It's all right. You, Mr. Pushpika, you just wait. Yes, go for second witness.
Much obliged, Mr. Honorable Tribunal, and again, apologies for any inconvenience caused from our side.
Yes.
With the permission of the Honorable Tribunal, I, Nafisa Binta Borhan, the counsel on the claimant side, would like to start the examination in chief, where the second witness would be Ms. Aisha Fariha. Can the counsel proceed, sir?
Yeah, sure.
Please state your full name and your position at Sweet Delights Limited.
Am I audible?
Yeah, you are audible.
I will be playing the role of Aisha Faria. As your Honorable Tribunal was already notified, one of our members was not able to join, and therefore I'm playing a double role, and I will also be giving the closing arguments.
Sure.
Okay. Can the Chief Examination Counsel please restate your question, please?
Yeah.
Please state your full name and your position at Sweet Delights Limited.
My full name is Aisha Faria, and I am the Head of Production, Procurement, and Quality Management at Sweet Delights Limited.
How long have you been in this position, and what are your primary responsibilities?
I have held this position for 5 years. My primary responsibilities include managing the procurement of raw materials, overseeing production processes, ensuring quality assurance, and ensuring compliance with internal and external standards, including sustainability and ethical sourcing.
Can you describe the process Sweet Delights Limited uses to ensure that raw materials, particularly cocoa, are ethically sourced and meet sustainability standards?
Our process involves procuring cocoa only from suppliers with internationally recognized certifications. As the company's COO was questioned, we only source our cocoa from organizations that are internationally recognized, and as also reiterated by my fellow witness, that the cocoa was obtained from Ghana, which was widely recognized internationally, and therefore we did not have any sort of indication to actually investigate further into their actual ingredients.
Were you involved in procuring the cocoa used in the dark chocolate pound cakes supplied to Nusantara Cakes Indonesia? If so, what steps did you take to ensure compliance with sustainability requirements?
Yes, I was directly involved. I ensured that all the cocoa was sourced from certified suppliers. Verified certification at the time of procurement, conducted supplier audits, and relied on independent certifiers to confirm compliance with sustainability requirements outlined in the exclusive supply agreement, which is an internationally recognized practice of getting conformity.
Okay, fine. Have you submitted that certificate to the tribunal?
I do not believe so, Mr. Arbitrator.
Yeah, have you submitted that certificate upon which you are relying upon so much?
The
certificate you obtained from Ghana, that's internationally recognized. Have you submitted that certificate before the tribunal?
We have not submitted it as an exhibit, Mr. Arbitrator.
You are two. The claimant has not filed any of the document, not yet. Unless you submit that document, you cannot rely upon that. The tribunal has to consider the document. What is the document? It must be in front of you.
Mr. Arbitrator, the document was mentioned in the facts of the case, the BIAC case, number 5.
Yes, you have mentioned, but those documents have to be filed before the tribunal. Have you filed it?
No, Mr. Arbitrator.
Oh, Salar, you proceed on. Yes, Chief, Examination Chief, proceed.
Much obliged, sir. Miss Aisha.
It is your duty to file the documents. You have not filed it.
Yes, sir. Apologies from our side.
This is the third time you press for apology. Yes.
Apologies.
This is fourth time.
Sorry, sir.
Yes, go on.
Much obliged, sir. Miss Aisha, did the cake supplied to Nusantara Cakes Indonesia meet all the specifications outlined in the stated facts, such as weight, size, texture, and appearance?
Yes, the dark chocolate pound cakes met all specifications, including a weight of 120 grams each, no preservatives or artificial colors, and compliance with taste, texture, and appearance standards as stipulated in the agreement, as confirmed by our internal quality control testing.
When did you first learn about the allegations of fraud in Ghana's certification scheme, and what steps did you take in response?
I first learned about the allegations on January 19th of 2024, following a televised expose. I promptly initiated an internal investigation to assess our supply chain and communicated with management to address the concerns raised by Nusantara Cakes Indonesia on January 27, 2024.
In brief, can you summarize the findings of your internal investigation concluded on 10th February?
Yes, that we want to know.
The investigation found that only a small portion of the cocoa used in the cakes originated from Ghana, which was under investigation for certification fraud. However, this did not affect the cake's quality or compliance with agreed specification.
Based on your investigation, did the use of cocoa from Ghana affect the quality of the cakes delivered to Nusantara Cakes Indonesia?
I'm sorry, can you repeat the question? It was cut off.
Sure. Ms. Aisha, based on your investigation, did the use of cocoa from Ghana affect the quality of the cakes delivered to Nusantara Cakes Indonesia?
No, the use of cocoa from Ghana did not affect the quality. The cakes remained within the agreed specifications for taste, texture, and appearances, and there were no consumer or regulatory complaints.
Have you taken any steps to prevent...
Ms. Aisha, one question. Ms. Aisha, you are saying that not all the cakes were made from the Ghana cocoa, right?
Yes.
A very small portion have been done with the Ghana cocoa.
Yes, Mr.
Have you satisfied your customer that this is not the fact? We did not do all the cakes by Ghana cocoa. Rather, a small portion has been done. Have you ever written any related to them, satisfying them about the matter?
Mr. Arbitrator, at the time of sourcing the cocoa from Ghana, we were not aware that the Ghana scheme was a fraud. internationally recognized scheme had become a fraud. And upon learning, we promptly admitted that a small portion of our cocoa was actually sourced from Ghana, and we let the respondents know, and we wanted to take mitigating options. We wanted to sit for negotiations, but the respondents just abruptly terminated the contract based on a small portion of non-compliance with the non-compliant Ghana cocoa.
It's all right. Proceed.
Yes. Yes. Thank you, Mr. Arbiter.
Much obliged, sir. Miss Asha, in your professional opinion, did Sweet Delights Limited comply with the quality and sustainability requirements of the agreement?
Yes. In my professional opinion, Sweet Delights Limited complied with the quality and sustainability requirements. We acted in good faith, relied on valid certifications which were valid at the time, and the minor sourcing issue did not impact the cake's quality or the agreement's core terms.
That would be all from our side. Thank you, Honorable Tribunal, for giving us the time.
Yeah, it's all right. So we'll proceed on to the respondent's submission. That's the opening statement by the respondent. Yeah.
Thank you, Mr. Arbitrator. Shall I convene?
Sure.
Okay. Miss Aisha, could you reiterate your official position or title at Sweet Delights Limited?
My official position at Sweet Delights Limited is a head of production, procurement, and quality management.
And how long have you held this position?
5 years.
5 years, okay. So could you briefly describe your main responsibilities at this position?
As I've already told the chief examiners, I have my primary responsibilities include managing the procurement of raw materials, overseeing production processes, ensuring quality assurance, and ensuring compliance with internal and external standards.
Okay, so would you agree that Sweet Delights Limited presents itself as a premium supplier with a strong emphasis on quality, ethics, and sustainability, right?
Yes.
Okay, so Ms. Faria, you've stated that as head of production, procurement, and quality, you have direct control over procurement and ensure all raw materials conform to the company and customer specifications. Is that correct?
According to the international guidelines, yes.
Okay, so would you agree that the responsibility for ensuring cocoa is ethically sourced lies squarely with you and your department?
Yes.
Okay, as a head of procurement and quality control, how did cocoa linked to fraudulent certifications enter your supply chain unlocked then?
Because, as I have already stated, we followed procedure of following international guidelines, the internationally accepted practices to check actual the acquiring process. So the Ghana cocoa, that a small batch of the cocoa was supplied from Ghana, which was at the time internationally recognized, and there were no way that Sweet Delights could know that the Ghana was sourced from unsustainable or fraud specifications.
Okay, Miss Aisha, but isn't verifying supplier certifications, and as Mr. Arbitrator also said that giving or providing a valid certification to the tribunal and to the respondent is your duty?
Okay, as to answer your question, I would like to address the email you supplied to us on, I think, 28th or 27th of January, where you specified the Ghana cocoa scheme. You were well aware that we provided we could have provided cocoa from the Ghana scheme, and it was actually internationally recognized. So you were well aware of the certifications. I do not understand why the exhibit of certifications is actually any sort of advantage to you, because you were already you already know about the certifications of Ghana.
Okay, Miss Aisha, but even if the certifications were provided validly, but isn't it your responsibility to know regarding the breach of the certifications from your supplier?
Yes, when the expose was aired, when the expose was aired. Prior to that, Ghana supplied, it is not the case that Ghana only supplied cocoa to us. Ghana also supplied cocoa to various international organizations, and it was highly accepted internationally up until the expose. And I followed all the protocols that is relevant to procuring sustainable cocoa. I sourced it from certified, it was a certified supplier. It was there were verified certificates. At the time of procurement, there was a supplier audit. There was an independent international certifications that were given to the Ghana scheme. They were all fooled by the fraud of Ghana. And we, as a small company inside Bangladesh, cannot actually say that we would reasonably foresee that the Ghana scheme was a fraud at the time of procuring, because all the certifications, all the documents matched. That was what we were supposed to do, even according to your contract, your sustainability standards.
Okay, but as a company in Bangladesh dealing with international customers, isn't it your liability to at least at least provide a ethically sourced cocoa to your buyers?
As I have reiterated, at the time of procurement, we were well aware, and we were under the pretense, according to the international documents, that the Ghana cocoa was sourced from a ethically sourced cocoa supplier.
So do you agree there was a lapse in some part of the time? You could not check it thoroughly.
No, I would not say that there was a lapse, because we, as I have already stated, we followed international protocols.
Okay, but Miss Aisha, as you stated that your official position requires quality management as well. So under quality management, do you manage the quality of some products ahead and leave the other products aside?
Okay.
So that your buyers can buy anything from the supply.
Now, your sustainability standards state that they have to be ethically sourced. The only part that's breaching the sustainability standard is that it is not allegedly ethically sourced, even though there is not still. We said that some part of our cocoa may be given from Ghana, but there is still no actual evidence as to anything substantial providing the fraud. And second of all, the quality of the cocoa was not actually affected, because your sustainability standards call for ethical sourcing. Maybe the Ghana cocoa was not ethically sourced, but the quality of the product was actually assessed, and it was absolutely brilliant.
Okay, but I know you have reiterated that the taste wasn't affected in your witness statement as well, right?
Not the taste, also the quality.
Okay, taste and quality. But isn't sustainability a contractual requirement and not a sensory requirement?
Yes, your general code of conduct and everything specifies that we obtain our cocoa from certified cocoa certified suppliers, sustainability suppliers. Yes.
So you agree that you have reached the contractual requirement?
We have no. If you can see, if you listen to that, is that we have sourced the cocoa from a certified supplier who was certified to be sourcing cocoa from ethical source.
Okay.
Furthermore, we did actually comply with our contractual obligations, because we did at the time provide it from a certified source. At the time that they have created the fraud, there was no way that we could have known, reasonably, forcibly known.
Okay, but the certification turned out to be fraudulent.
Is an international scam or fraud? Actually, do you have any evidence as to our company having any sort of contribution to that?
A question regarding this, Ms. Aisha. So even if minimal, wouldn't any use of unethical cocoa breach the agreement and risk reputational harm to the respondents?
Again,
because I would classify it as well, because respondents' major part of their branding is based on sustainability standards. You know that we have presented exhibits regarding that to the tribunal, to the claimant as well, right?
Again, at the time of producing that cake, at the time of actually delivering the cakes, we were still not aware that the Ghana certification was a fraud. After we got to know it, after an internal audit, we got to know that some of the cocoa was sourced from Ghana. We did not make any cakes from that source. So how is it on our how is it a breach on our parts when we have
Miss
supplied
Aisha,
the cocoa from a certified source? Yes.
being a quality manager, isn't it your responsibility to be aware about each and every product that goes on from your side to the buyer side, about the
Again.
quality assurance, about the sustainability assurance, about the procurement assurance?
Again, I will reiterate that I was aware of the certifications that were internationally recognized. I was aware of the quality. The quality was not affected. The sustainability ethics was breached by Ghana, but the quality was not affected. There was no health concerns. There was no taste concerns. The only part was the sustainability concern. The sustainability certificates were provided by international organizations, and therefore, as my role of head of procurement and management, there was no problem with the quality, and the certifications were provided as per your contract.
Okay, so under Article 17.2, sorry.
Yeah, I have one question. It has been mentioned that small portion has been affected. So could you explain more on that? I mean, what small portion and then what happened to the rest? I mean,
Yes, Mr. Arbitrator. We source our cocoa from various sources, various certified sources, and this Ghana scheme was only a small part of that. When we got to know, when the respondents emailed us about the non-compliance, we immediately started an investigation into our supply, and we found out that a small portion of our cocoa that we sourced from the international organizations was a part of the Ghana scheme. And after getting to know that, we stopped any sort of production from the source, from making the cakes from the cocoa source from the Ghana scheme.
Yeah, but the breach, substantial failure of your performance, and there is a termination definitely. And I mean, is there any link of the product, even if its quality is not been affected, but it still, as per the requirement of contract, it has to be sustainable. Doesn't only okay that if it is good quality is okay, but that still has to be sustainable. So how do you clarify that the product which has been supplied and which is part of the the failure of your compliance is the exact product where that small portion has been used?
Mr. Arbitrator, at the time of sourcing the cocoa, we were under the impression that the cocoa was actually sustainably sourced. It had valid certificates, and the only people that could be blamed.
No, I'm not asking. I'm saying supply chain tracing. Have you done the supply chain tracing that this particular product has been used, and because of that, there is a breach? I mean, the contractual breach is directly linked with the small portion which is not sustainable. So could you say that clearly that this is even if the customers complain or is not linked with that the breach, or the product has been used for termination is kind of does not fall within that small portion? It's like separate. Can you differentiate?
Mr. Arbitrator, we trace back our supplies, the cocoa that was used, each cocoa that was used in the cakes that we delivered. We found out that a small portion did get made from the Ghana scheme cocoa, and the rest of the cocoa that we had sourced from Ghana, we stopped productions with those that cocoa. So after getting to know the fraudulent actions made by the Ghana scheme, we immediately stopped making cakes from that cocoa.
Okay, thank you.
Thank you, Mr. Arbitrator.
It's all right. Proceed on.
Do you have
any more questions?
Do you have any time remaining?
No more
Yeah.
time is remaining.
Thank you so much. I end my examination here.
Thank you, Mr. Arbitrator. Thank you.
Yes.
Honorable members of the tribunal, may I begin?
Sure.
It is my honor to appear before you today as counsel for the respondent 𝐷𝐎𝐷𝐾 Indonesia in this matter initiated by claimant Sweet Delights Limited. I am Pushpika
Yeah.
Thapi, the opening counsel. Before I
Yeah.
proceed to the substance of this case, let me formally confirm that the respondent accepts the jurisdiction of this honorable tribunal under Clause 20 of the Exclusive Supply Agreement dated 7 April 2021, pursuant to Bangladesh International Arbitration Center Rules 2019. We acknowledge that the seat of arbitration is Dhaka, Bangladesh, with English as the language of the proceedings in accordance with BIAC Rule 19.1. The applicable substantive law is United Nations Convention on Contracts for the International Sales of Goods, domestic laws of Bangladesh, and where the CISG is silent, the UNIDROIT Principles of International Commercial Contracts 2016 apply as supplementary guidance. This dispute arises out of long-standing exclusive supply agreement. The respondent 𝐷𝐎𝐷𝐾, company operating across Southeast Asia, known for its strong ethical sourcing policies and public commitments to sustainability. In early 2021, the respondent issued a tender inviting manufacturers to supply its dark chocolate pound cakes on the condition that all cocoa used must be ethically and sustainably sourced with proper documentation. The claimant, Sweet Delights Limited, participated in this process and was awarded the contract based on its written commitments, including representations regarding sustainability certifications. Deliveries commenced in May 2021. The contract was not solely about volume or cost. It was built around one core value, ethically certified cocoa. The agreement included multiple express clauses confirming this foundational requirement. Clause 2.2 of the Exclusive Supply Agreement required full compliance with ethical sourcing and certification. The tender submission described sustainability as critical and non-negotiable. The Supplier Code of Conduct, expressly accepted by the claimant, declared in Clause 2.1.1, sustainability is non-negotiable. Clause 2.1.3, a basic breach occurs when sustainability standards are not met. These documents together created a clear, documented understanding that sustainability was not peripheral, it was fundamental. In January 2024, the factual landscape changed significantly. On 19 January, an international media expose revealed widespread fraud in the Ghana Sustainable Agriculture Certification Scheme, a scheme used by the claimant to source cocoa. In response, the respondent launched an internal compliance review on 23 January. On 27 January, we issued a formal notice to the claimant requesting verification documents for cocoa certification. That same day, a widely shared editorial title from Trusted to Tarnished linked Nusandra to the Ghana scandal. This resulted in viral social media backlash, termination of supply contracts by clients such as 𝐷𝐿𝐧𝐭𝐞𝐫 Group, suspension of partnerships with ethical retailers, and a sharp decline in weekly sales. On 10 February, the claimant responded in writing saying, some batches of cocoa used in our supply did not meet the sustainability standards required under Clause 2.2. This admission was critical. It confirmed that the cocoa used did not meet the standards that had been contractually required from the start. On 12 February 2024, the respondent exercised its right to terminate the contract. The respondent has submitted all relevant exhibits to assist the tribunal in reviewing the factual record. These include exhibit editorial from Trusted to Tarnished, article dated 27 January 2024, exhibit 𝐷𝐿𝐧𝐭𝐞𝐫 termination letter detailing reputational harm and client withdrawal, internal audit summary summarizing findings from our post-breach review, claimant's email 10th February admitting non-compliance, exhibit damages summary outlining losses sustained $1.44 million for unsellable cakes, $500,000 for reputational harm, $500,000 for lost businesses, and $100,000 in audit costs. These documents provide a comprehensive record of the sequence of events, the consequences suffered, and the basis for the relief sought. The claimant has approached this tribunal seeking payments for good delivered and a declaration that the contract was wrongfully terminated. The respondent, in turn, seeks damages resulting from the admitted breach and submits that termination was validly executed pursuant to the contract. While I will not present arguments at this stage, the tribunal may later be invited to consider the centrality of ethical sourcing to the commercial agreement, the impact of the claimant's admitted non-compliance, the financial, reputational, and legal consequences that followed, whether the termination was lawful and proportionate, the extent to which damages claimed are supported by evidence. Honorable members, this is not merely a matter of supply distribution or product quality. It concerns the very identity and credibility of a brand built on trust and sustainability. The factual record, as it stands, shows the respondent took timely and responsible steps in the face of a serious supply failure. We thank the tribunal for its attention and confirm that we stand ready to assist during the course of this proceedings. Thank you. Without advancing arguments, it is respectfully submitted to the tribunal that may be required to consider the following issues.
Yeah, sure. Yes.
Whether the cocoa supplied met the ethical sourcing obligations agreed upon in the contract, the significance of the claimant's admission regarding non-compliance, the effect of this non-compliance on the commercial basis of the contract, whether the respondent's termination on 12 February was carried out in accordance with contract provisions, the extent of reputational, financial, and operational impact suffered by the respondent, the degree to which both parties fulfilled their obligation under international instruments such as the CISG and unit joint principles. Following the termination, the claimant initiated this arbitration seeking payment for goods previously delivered, a declaration that the termination was unlawful, and monetary damages lost for commercial opportunity. The respondent, through its statement of defense and counterclaim, contests these claims and seeks damages for unsellable inventory, reputational harm, compliance and audit costs, and commercial losses from third-party contract terminations. Both parties have filed written pleadings, submitted evidentiary documents, and prepared witness for examinations in accordance with BIAC procedure. Honorable Tribunal, this case will require a close examination of facts, documents, and obligations freely undertaken. While today is not the occasion for arguments, the respondent is confident that the record will reflect the seriousness of the issue at stake and the fairness of its action in the light of what transpired. We thank the tribunal for its attention and confirm that the respondent stands ready to assist through these proceedings. Thank you. Now I would like to invite our witnesses to carry on the case further.
Yeah.
Thank you, Mr. Arbitrator. I, as the examiner of the witnesses, would like to state that we have two witnesses for the witness presentation. The first is Mr. 𝐅𝐈𝐧𝐭𝐞𝐫. He is the MD and the Legal and Compliance Officer. And the second is Ms. Adi Praseo. She is the head of purchasing at Nusantara Cakes, Indonesia. Shall I convene with the first witness? Thank you, Mr.
Yeah.
Okay. So, Mr. 𝐅𝐈𝐧𝐭𝐞𝐫, good afternoon.
Good afternoon.
For the record, could you please state me your full name and position at Nusantara?
My name is Matthew 𝐅𝐈𝐧𝐭𝐞𝐫. I'm the Managing Director of Nusantara Cakes, Indonesia, and while that's my primary role, I also oversee key legal matters within the company.
Name of the witness? What is the name of the witness?
Matthew 𝐅𝐈𝐧𝐭𝐞𝐫, MD of the company. 𝐅𝐈𝐧𝐭𝐞𝐫.
Matthew 𝐅𝐈𝐧𝐭𝐞𝐫.
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 𝐅𝐴𝐺𝐻𝐭.
𝐅𝐈𝐧𝐭𝐞𝐫, yes. And acted by you?
Acted by me, Sangam Paudel.
Your name is Sangam Paudel.
Yes.
Yeah, proceed.
Okay. Could you please state me your position at Nusantara?
I am the Managing Director of Nusantara Cakes, Indonesia, and while that's my primary role, I also oversee key legal matters within the company.
Okay. Could you please describe your responsibilities? A little brief.
Okay. I have been with Nusantara since day one. In the early days of Nusantara, we couldn't afford to hire separate legal and executive teams, so I took on both roles thanks to my dual degree in law and business management. In those days, I handled all the legal responsibilities myself. Even now, though we have a capable legal team, I still personally review contracts involving high-stakes legal matter. Nusantara, it isn't just a business to me, it's practically my child. It's something I have built with my own hands. I have poured years of effort into establishing Nusantara as a brand, That's why I'm very active in critical decisions, as I see it as my responsibility to safeguard everything we have worked so hard to build.
Okay, Mr. Rahat. So let's turn to the exclusive supply agreement signed with Sweets Delight. Were you directly involved in the tender process and contractual relationship with Sweets Delight Limited?
Yes, I was very involved from the start. Given how important this contract was to our product line and brand values, I personally oversaw the negotiations and documentations. We weren't just looking for a supplier, we were building a relationship based on trust and shared principle, which we genuinely believed Sweet Delights understood and respected. Unfortunately, they let us down. What we believed would be a value driven partnership ended up compromising everything we stood for.
Okay, so when was the agreement executed?
So the agreement, it was signed in April 7, 2021 and executed after that.
Okay.
Where? The venue, where the venue? Where it was executed? Dhaka or Indonesia?
Indonesia.
Yeah.
So can you clarify whether the exclusive supply agreement imposed binding obligations on the supplier with respect to ethical sourcing of ingredients?
Let me be precise. Ethical sourcing, it wasn't just a checkbox. It was the absolute core foundation of the agreement. It was central to the agreement and to our brand. The clauses in the contract.
Apologies, Mr. Arbitrator. I have an objection. Witness has somehow misled the tribunal in thinking that the contract was signed in Indonesia, but it was actually signed in Bangladesh on the 7th day of April of 2021. I am referring to the exclusive supply agreement
This is not the objection. You can tell it at the time of argument. Yes. Go on, proceed.
Okay. So you could proceed.
Yeah.
Okay. Can you repeat the last question you asked?
Okay. So can you clarify whether the agreement imposed binding obligations on the supplier with respect to ethical sourcing of ingredients?
So ethical sourcing, as I mentioned, was not just a checkbox. It was the absolute core foundation of the agreement. It was central to the agreement and to our brand. The clauses in the contract, they were very clear about this, and Sweet Delights, they agreed to the clauses without any hesitation. In fact, we chose Sweet Delights precisely because they claimed to share that commitment. We believe they were the supplier who aligned with our values.
Okay. So what importance does your company place on ethical sourcing?
So ethical sourcing, it is the core concept of our brand. It is how we have built customer loyalty and industry respect. When people buy a cake from us, they believe they are supporting sustainability. We don't just talk about ethics, we live by it, and in fact, it's our whole identity. That's why this entire situation has been so deeply painful. This breach, it hasn't just affected a contract, it has brought our whole brand into question, and after years of hard work building our reputation, it has crumbled overnight.
And were these requirements communicated to Sweets Delight Limited?
Of course, they were communicated with absolute clarity. The obligations were included in our official tender documents, then emphasized again in the contract and reconfirmed through our code of conduct and numerous meetings we sat on. And Sweet Delights not only acknowledged them, they showcased that their ethical sourcing claim at various events, which made us believe them to be genuinely aligned with our values. But our trust was misplaced, and here we are facing the consequences.
So to be clear, they did agree and made necessary provisions according to the agreement.
Yes, they did that too without any hesitation. In fact, they didn't just agree only on the contract, they presented us maps, certificates that made it look all real. They showed us exactly what we wanted to see, and that's why we trusted them.
Okay, Mr. Raharjo, up until January 2024, deliveries under the contract proceeded without interruption and based on the assumption of full compliance. Is it correct?
Yes, that is correct.
Okay. Could you please explain what significant events occurred in January 2024 that prompted your organization to reevaluate Sweets Delight's compliance with its ethical sourcing obligations?
So in January 2024, a television news report revealed the widespread fraud in Ghana's sustainability agriculture certification scheme, which exposed the fake audits, fake certificates, and systematic abuse of sustainability labels. This immediately raised concern to us, as Ghana was a well-known source of Sweet Delight's cocoa, Up until that point, we have received regular deliveries under the assumption that all the ethical sourcing obligations they were being met. But after that expose, we had no choice but to re-evaluate everything. We halted distribution, then launched an internal review. How could we continue selling a product we knew might violate everything we came to stand for? It would have been not just irresponsible but totally dishonest to our customers. We have built our brand on trust and ethics, and we could not afford to turn blind eye on that.
Okay. So can you briefly explain the internal steps your company took to investigate Sweet Delight's compliance with ethical sourcing terms after learning of the COCA certification fraud allegation?
So after the exposure, our response, it was immediate. We launched a full internal investigation and then reached out to Sweet Delight's for their answer. And you know what they responded? They denied everything at first and simply pretended that there was no issue at all. It was only after a public report exposed the truth that they finally admitted their failure. This foot dragging, it has wasted crucial time and directly caused us significant reputational harm. We then pulled their product from the market, not because we were legally forced to, but because we feel profound responsibility towards our customers to do the right thing. A responsibility Sweet Delights have clearly disregarded.
Okay, Mr. Harzo, could you explain the role and content of the general conditions of contract and code of conduct for suppliers that Sweet Delights has accepted without reservation, particularly regarding sustainability obligations?
So the general code of conduct, the general condition of contract and the code of conduct for suppliers, they are the foundational document that define the standards we expect from all our partners. These weren't just a vague guidelines, they are the binding commitments. In fact, both document, it clearly states that all the ingredients, particularly coca, must be sourced in accordance with the recognized international sustainability standard. Sweet Delight, they accepted this condition without a single reservation during the tender process. They fully agreed to it. That's why this breach is so disappointing. Like these standards, they weren't exactly hidden. They were central to the relationship, and Sweet Delight knew exactly what was expected of them.
Okay, so
One
Mr.
minute is left.
Sorry, ma'am.
1 minute is left.
Okay, thank you, ma'am. So, Mr. Rajzo, you're the legal officer as well. How would you characterize the nature of the breach?
This is simply plain and simple fundamental breach. The obligation to deliver ethically sourced coca was not a secondary obligation. It was the core heart of the agreement. Sweet Delight, they not only failed to meet that obligation, they didn't even exercise basic diligence to verify their supply chain. And the result, we have lost client, our brand image has taken a serious hit, and we are left repairing damage we didn't even cause.
So, and did you evaluate any alternatives to termination before exercising your contractual right to end the agreement?
We took our duties very seriously and simply followed the contract's rule. The agreement was clear. If they didn't meet sustainability standard, it was breach of the contract. Once Sweet Delight admitted that coca wasn't up to the standards, our path was already laid out by the contract itself. We weren't looking for excuses or quick fix. Our only goal was to ensure we had handled this by the law, openly and correctly. When a problem hits the very core of our agreement like this, continuing the partnership wasn't just possible or responsible from our side.
Okay, thank you, Mr. Rajzo.
Time
Thank
is
you.
over.
Yes, cross-examination.
Greetings, Mr. Arbitrator. I'm Mohammed Naim Haider. I'll be playing the part of the legal counsel responsible for cross-examination of the respondent. With your permission, may I begin, Mr. Arbitrator?
Yeah, sure.
So, you are Mr. 𝐁𝐈𝐧𝐿, is that correct?
Yes.
You are, I'm a bit confused, Mr. 𝐁𝐈𝐧𝐿. Are you the legal compliance officer or are you the MD of Nusantara? Could you explain? Could you tell me? Which are you, Mr. 𝐁𝐈𝐧𝐿?
Okay, I have already clarified this before, but let me clarify it for you. I am mainly the MD of the company, but I personally oversee the critical legal
So
compliances.
You're both.
Yes,
You're
I'm
both
both.
the legal compliance officer as well as the MD. Is that correct?
Yes.
Mr. 𝐁𝐈𝐧𝐿?
Yes.
Yes, okay, good. So, Mr. 𝐁𝐈𝐧𝐿, my first question, that is a clarification. My first question for you would be, Mr. 𝐁𝐈𝐧𝐿, is that an internal audit by the respondent initiated on the 23rd of January, this suggested that the claimant's supply chain may be affected. Is that correct, Mr. 𝐁𝐈𝐧𝐿?
Yes.
Yes or no?
Yes.
Yes, okay, good. And then on the 10th of February, Mr. 𝐁𝐳𝐀, the claimant suggested that their supply may contain a small portion of cocoa that did not comply with your standards. Is that correct, Mr. 𝐁𝐳𝐀? Yes or no?
They didn't suggest, they confirmed.
Yes or no? Did they suggest that?
They confirmed, yes, they confirmed.
Yes, okay, yes. Would you say, Mr. 𝐁𝐳𝐀, that Nusantara suffered reputational losses because the alleged non-compliance, it became public knowledge?
Yes.
Yes or no, Mr. 𝐁𝐳𝐀?
Yes.
Yes,
Yes, we
okay,
suffered.
good.
Yes, the learned
internal
counsel,
audit.
the
Yes.
witness is
Yes,
very
yes.
confident. So you are talking the other way.
Yes, sir. Yes, sir. Mr. 𝐁𝐳𝐀,
Yes.
the internal audit that you initiated and the admission, quote unquote admission that you say, both of these were private communications. Is that correct, Mr. 𝐁𝐳𝐀? Both of these were private.
Yes.
Yes, okay. Both of
Yes.
these were private. They became, how did they become? You say that they became, you suffered reputational losses because they became public. How did they become public, Mr. 𝐁𝐳𝐀? How could they become public unless there was any confidentiality breach, Mr. 𝐁𝐳𝐀?
Let me clarify. You must be confused. We had the knowledge about the scam from the public information that came into news. We ourselves have the knowledge
That
about
is
that, and
incorrect,
that's
Mr. 𝐁𝐳𝐀. That is
accessible to the
incorrect.
public
That is
as well.
incorrect. The public exposure that you refer to, it did not link, our company did not link Sweet Delights to the Ghana certification scheme. Rather, it was your own audit and the subsequent admission, you say, by the claimant that suggested that their cocoa might have originated from Ghana. Therefore, Mr. 𝐁𝐳𝐀, any reputational damage that may have arisen to you, it must have been from negligence on your part, from breach of confidentiality from your part, from it spreading that your cake.
Oh, you make the question short.
What is the question?
The
What is the
learned counsel,
question?
you make the question short. It's a long question. This cannot be allowed.
Yes,
What is
sir.
the
Okay,
question?
so, Mr. Arbitrator, I would say that you say that this became public knowledge, Mr. 𝐁𝐳𝐀. It could not have become public knowledge without it being leaked from Nusantara itself, Mr. 𝐁𝐳𝐀. Yes or no?
It was public knowledge, and that it was already a public knowledge, and that's how we found out about it too. We knew it from the public knowledge, not from your
Mr.
side.
Arbitrator. The
That is
counsel
wrong,
is trying
Mr.
to lead the
𝐁𝐻𝐳.
witness.
That is wrong, Mr. 𝐁𝐳. It was not Sweet Delights being part of the Ghana scheme. That was
Objection,
not
Mr.
public knowledge,
Arbitrator.
Mr. 𝐁𝐳. That is something that was found from your internal audit that was private, as well as from the admission from the Sweet Delights itself. It was a
Objection,
private
Mr. Arbitrator.
communication, Mr. 𝐁𝐳, and it could not have become public without
Counsel is trying to
you
lead the
leaking it.
witness.
Yes or no, Mr. 𝐁𝐳?
As I already
Yes or
mentioned,
no?
it was already a public knowledge. Before we had to do anything, it was already a public knowledge, and it is public knowledge that our company is connected to your company, and we rely on you to source the coca. It is a public knowledge. We are a big company.
Yeah, I have one question. You said that you have suffered serious reputational damage. Have you quantified the damage, how it becomes serious?
Yes, we have suffered
Mr.
serious
𝐁𝐳.
reputational. Let me answer. Let me answer, please.
Yeah, sure,
As I
Mr.
was,
𝐁𝐳.
as I was saying, we have suffered serious reputational harm. That was after the public's exposure of the scam, the Ghana scam, and the serious reputational harm. We have quantified that as backlashes in the social media, then after the loss of businesses because of that exposures and other exposures that has led us to tarnish our name.
Mr. 𝐁𝐳, was there any public linking that linked Sweet Delights to the exposure? There was not, Mr. 𝐁𝐳. There was no public
It is a
linking.
public knowledge that we are linked to your company. It is a public knowledge, so everyone can connect the dots.
Yeah, have you done prior due diligence of their company before starting business with them?
Can you repeat?
Any due diligence of the company you're dealing with, the Bangladeshi company?
Yes.
Prior to Sweet Delight, have you done any due diligence of Sweet Delight?
This is the first time we were doing any dealings with them since 3 years, almost 3 years.
Okay. Please proceed.
Mr. 𝐁𝐈𝐧𝐭, I would like to ask you, where are you getting that our company was linked to the expose that you mentioned? There is no indication of that in any of the facts, Mr. 𝐁𝐈𝐧𝐭.
That's a common knowledge. Your company sources their coca from the Ghana. It's a common knowledge. It is mentioned in the fact sheet as well, and my official counsels will clarify that.
That is not public knowledge, Mr. 𝐁𝐈𝐧𝐭. And
it is a knowledge according to the fact sheet.
All right, Mr. 𝐁𝐈𝐧𝐭.
And let me confirm. You
show me, Mr.
confirm.
𝐁𝐈𝐧𝐭. Could you show me?
Let me
Mr. 𝐁𝐈�𝐧𝐭, could you
let
show
me
me
speak.
where-
Let me speak, please.
Yeah, okay.
Let me speak. You're not letting me speak. How can I answer you? So you have confirmed that your coca comes from Ghana on their confirmation on 10th February.
Yes, that was private knowledge, Mr. 𝐁𝐈𝐧𝐭. Do you deny it? That was private knowledge shared by email to you. Yes or no?
Even
Mr.
though that
𝐁𝐈𝐧𝐭?
was a private knowledge, it is public knowledge that our company uses that coca.
How, Mr. 𝐁𝐈𝐧𝐭? How is it public knowledge that your company is linked to that or our company is linked to that? That is not public knowledge, Mr. 𝐁𝐈𝐧𝐭. That is all private. That is all revealed exclusively to you, Mr. 𝐁𝐈𝐧𝐭.
Is it really relevant, Mr.?
It's not relevant at all. You know, question, it will not go. It's not relevant at all. Yes. Further.
Mr. Advocate, this leads to the breach of confidentiality. That is why I am pursuing this line of questioning. I will direct this arbitral tribunal to the exhibit shared by the respondent regarding the email that they received from from the 𝐁𝐈𝐧𝐭 Corporation. I will direct this arbitral counsel to that. Mr. 𝐁𝐈𝐧𝐭, you are aware of the termination letter that was given by 𝐁𝐈𝐧𝐭 Group. Is that right?
Yes.
Yes. The second letter that you let them know of the non-compliance of your case with the sustainability standards on the 10th of February. Is that correct?
Yes.
Mr. 𝐁𝐈𝐧𝐭?
Yes.
Yes. You let them know, you received confirmation from the claimant on the 10th of February, and you let them know also on the 10th of February, Mr. 𝐁𝐈𝐧𝐭. Don't you think that this is a breach of confidentiality? That is private information that you got from the claimant and you let them know on the same day. That is a breach of confidentiality. Wouldn't you say that, Mr. 𝐁𝐈𝐧𝐭?
Well, we owe our obligation to our partners to confirm about everything that goes in our company, unlike you do.
Mr. 𝐁𝐈𝐧𝐭, you terminated the contract with Sweet Delights on the 12th of February, and you told them this, you disclosed confidential information with them before even you terminated the contract with us, Mr. 𝐁𝐈𝐧𝐭. Don't by Article 19 of the supply agreement, you have to take a consent of disclosure before you are allowed to disclose such private information to others. Isn't that correct, Mr. 𝐁𝐈𝐧𝐭?
Let me clarify your misconception. They ended the agreement, the 𝐁𝐈𝐧𝐭 Cafe. They ended the agreement with us based on the exposure, not based on what we gave them.
It is said, the paragraph itself says, Mr. 𝐁𝐈𝐧𝐭, that based on what you admitted to them on the 10th of February, that your cakes were not compliant to your own standards, Mr. 𝐁𝐈𝐧𝐭. They did it based on that. Mr. 𝐁𝐈𝐧𝐭, you shared with them confidential information pertaining to this contract. Did you deny it or did you accept it, Mr. 𝐁𝐈𝐧𝐭?
Can you repeat the question?
You told them information that was provided by the claimant to the respondent, you told them this even before terminating the contract. Yes or no, Mr. 𝐷𝐿𝐧𝐭?
They terminated based on the public knowledge information.
There is, as I've said before, Mr. 𝐷𝐿𝐧𝐭, there is no indication that
Objection,
this was public
arbitrator.
information. You are making this
Relevancy
up,
of the
Mr. 𝐷𝐿𝐧𝐭. Do
question.
you deny
Yeah,
it?
this may go as a suggestion, not more than that. A suggestion. Yes.
Mr. 𝐷𝐿𝐧𝐭, this is the breach of confidentiality per Article 19. You deny it, Mr. 𝐷𝐿𝐧𝐭.
Can you repeat? I am not understanding what are you asking.
Mr. 𝐷𝐿𝐧𝐭, you disclosing information that was private to this contract, that is against Article 19. Did you take any consent for disclosure, Mr. 𝐷𝐿𝐧𝐭, before you inform this to Luxor?
I repeat, they
Yes or no?
terminated the agreement because due to the public available information. We have not done anything today. We have not said anything to them. They
That is
terminated
not
the.
the question, Mr. 𝐷𝐿𝐧𝐭. That is not the question. The question is that, did you take any consent for disclosure before you reveal to them?
We
on
have
the
not
10th of February
disclosed. Why
that-
would you take your
Sorry, Mr. Arbitrator, objection. The
Yes.
counsel is trying to lead the witness.
Yes, sustained. Objection sustained. Yes.
Mr. 𝐷𝐿𝐧𝐭,
Proceed.
media disclosure?
Mr. 𝐷𝐿𝐧𝐭,
Yes.
that does constitute a breach of confidentiality. You have revealed to them private information.
Mr.
pertaining to this
Arbitrator,
contract.
I have
You
not
deny it.
revealed
line of
any
question.
private information.
It's a repetition.
𝐷𝐿𝐧𝐭.
Yes. Go to the next question. This is repetition.
Mr. 𝐷𝐿𝐧𝐭, then can I direct this arbitral counsel to the screenshot presented by the respondent? The exhibit, the screenshot exhibit. All right. Mr. 𝐷𝐿𝐧𝐭,
Yes.
the screenshot here says Nusantar case. Surely you cannot have mistaken the name of your own company, Mr. 𝐷𝐿𝐧𝐭.
Yes.
The screenshot, notice in the above part, is written that it's called Nusantar case. Have not mistaken the name of your own company, Mr. 𝐷𝐿𝐧𝐭.
When there is a
Objection,
breach,
Mr. Arbitrator. Relevancy of the question.
it's so irrelevant.
The relevance of the
We're
question
talking
is
about
that
breach of the contract.
that
How is spelling of our company relevant here?
it is relevant because it suggests that you may have falsified. That suggests, isn't it?
You're inaudible.
That suggests
Yes.
that faith on your part, Mr. 𝐷𝐿𝐧𝐭, that you have falsified an exhibit. It says that your company's name is called Nusantar Group, Nusantar Cakes. That is erroneous, Mr. 𝐷𝐿𝐧𝐭, isn't that?
That does not change the fact that we have suffered social media backlash.
Mr. 𝐷𝐿𝐧𝐭, I will direct
Time
you
is
the
over.
number of reactions.
Yes.
Thank you, Mr. Arbitral Tribunal, for allowing us to go for cross-examination. Thank you.
Yes. Yes, next.
Mr. Arbitrator, I shall convene the witness examination of our next witness, Ms. Adi
Yeah.
Prasetyo,
Sure.
Head of Purchasing at Nusantara Cakes, Indonesia.
First name?
Ms. Adi Prasetyo, ADI,
Miss Adib, ADI,
PRASE,
ADI,
ADI, then the last name is PRASE, TYO,
PRSE,
TYO.
TYO. Prasetyo.
Prasetyo.
Yes. Yeah.
Yes, sir. She's the head of purchasing at Nusantara Cakes, Indonesia. Shall I convene, Mr.
Yeah.
Arbitrator?
Yeah. Who left? Who left?
Sir, she's the head of purchasing.
Yes. Acted by?
Acted by Dibisha.
Hmm? Yeah,
Dibisha
call
Kadri.
your routine. Call your witness.
Okay. So, good afternoon, Ms. Prasetyo. For the record, could you please state me your full name and position at Nusantara?
Good afternoon. My name is Adi Prasetyo. I am the head of purchasing at Nusantara Cake, Indonesia.
Okay. Can you outline the key functions and... Sorry, sir?
Now, the person who you are examining, her
Yes, sir.
name is Dibisha Parsi.
Karki.
Huh?
Ki. Yes.
Yeah. Karki. Yeah.
Sorry,
Proceed.
okay. Can you outline the key functions and responsibilities you hold in your current position at Nusantara Cakes, Indonesia?
Sure. As a head of purchasing, I lead the team responsible for sourcing all the ingredients and products for Nusantara Cakes. My key duty is ensuring that every supplier meets our stringent quality and sustainability standards. We don't just buy ingredients. We secure our brand's promises to customer, ethically sourced, high-quality products. I oversee tender processes, vet suppliers.
Keep the answer short. Keep the answer short.
Okay. Negotiate contracts and monitor ongoing compliance. In a sense, I am guardian of our ethical source place.
Okay. So when your company launched the cake supplier tender in early 2021, what made a bid competitive from a sourcing perspective?
Okay, let me be clear. Price was never our sole focus. For us, the most competitive bids were those that could prove commitment to sustainability. We required verifiable certification on ethical sourcing, especially for coca, which is notorious for supply chain abuses. We scrutinized documentation, sourcing maps, farmer testimonials, anything to ensure a supplier's promises were not just marketing fluff. The best bids demonstrated transparency, integrity, and an unwavering alignment with our code of conduct.
Okay. So can you describe the presentation made by Sweet Delights Limited at Asian Food Fair in Dhaka and how it influenced your assessment of their suitability as a supplier?
Yes. The Dhaka Food Fair. I still remember it vividly. Sweet Delights put on a compelling show that they displayed sourcing maps with beautiful meticulous detail, shared testimonials from supposed coca farmers, and made a heartfelt case about sustainable practices. They didn't just say we are ethical. They showed us. Their King Delight cake was positioned as a beacon of ethical luxury. Frankly, it was impressive. Their presentation directly influenced us. We were convinced they shared our values and could meet our strict criteria. In retrospect, it feels like a performance, but the time it won them the contract.
So to be clear, you would have not selected them if they had not made those representations, right?
Absolutely not. Let me be blunt. Without those representation, those assurance of ethical sustainable sourcing, they wouldn't even have made our shortlist. We are premium brand built on sustainable values. Ethical sourcing wasn't just a preference, it was a condition. Sweet Delight knew this and pitched themselves as the perfect fit. Had they admitted even a hint of supply chain risk, they would have been rejected immediately.
Okay. So can you describe the monitoring practices your department employed to verify that Sweet Delights was meeting its obligations under the supply agreement?
We employed multi-layer approach. First, we require regulator certification update, actual documentation proving sustainable sourcing. Second, we conducted random checks on the paperwork and we trusted but verified their claims because the contract explicitly obliged them to maintain credible certification at all times. But I'll admit we relied on their honesty too much. They always produced polished official looking documents. It turned out that these documents weren't worth the paper they were printed on once the fraud in Ghana scheme was exposed.
So when you became aware of the fraud in Ghana's certification system, what immediate steps did you take?
The news hit us like a lightning bolt. A televised expose revealed systematic forgery in Ghana certification scheme. We reached immediately. On January 2023, I ordered a full internal audit of Sweet Delight supply chain. By January 27, we had enough red flags to suspend all deliveries and payments. We also formally notified Sweet Delights, giving them a chance to explain. We didn't want to jump to conclusion, but the risk to our brand was too high to wait.
Okay. So can you say what prompted your company to initiate an internal audit as soon as the reports about Ghana's certification fraud surfaced?
Because our brand is our promise, we cannot sell cakes claiming ethical sourcing, even if a shadow of doubt falls on their supply chain. The public expose left us no choice. If Ghana's certification was fraudulent and our supplier was using that coca, we effectively lying to our customers. We had to know the truth immediately, and internal audit was the only responsible, ethical, and legal defensible response.
Okay, so can you elaborate on the material findings that you found out on compliance deficiencies?
Yes, the audit was damning. It was found that Coca Sweet Delights used very likely sourced Ghana's, the very country exposed for fraudulent certification practices. Even worse, they could not produce any reliable, verifiable alternative certification. This wasn't just a small oversight. It was a total failure of their obligation to maintain credible documentation. They admitted on February 10 that their cakes contain coca, failing our sustainability criteria. This was a direct breach of contract's core requirement, not some technical error, sir.
So when on February 2024, when Sweet Delights admitted that their cakes contain coca, failing to meet your sustainability criteria, how did this admission influence your assessment of the situation then, and and the contractual breach that followed?
That admission was the final nail in the coffin. Up to that point, I was willing to give them the benefit of the doubt, but when they admitted it, they essentially confirmed they had been deceiving us for years. It wasn't an isolated slip. It was a fundamental betrayal of our agreement. It destroyed our ability to market our cakes as ethically sourced. It wasn't just a breach, it was a death of trust. At that moment, termination became unavoidable.
Okay, so to your knowledge, did Sweet Delights ever disclose during the tender process that their supply chain might include coca from Ghana's certification scheme?
Never, not once. In fact, they went out of their way to paint the opposite picture. They highlighted direct farmer relationship and certification. If they had even hinted at Ghanaian sourcing, especially given Ghana's known risk, they would have been instantly disqualified. Their entire pitch was about certainty and transparency. That turned out to be smoke and mirrors.
Sorry. The council would like to clarify regarding the timing of the examination.
Yes, what is the time left?
How much
Tell
time is
them what is the time left.
2 minutes is left.
Sorry?
2 minutes is still left.
Thank you so much, ma'am. Okay, so generally wrapping up the examination, I would like to ask you a last question. What would have been the consequences for Nusantara if consumers learned that the cakes contained unethically sourced cocoa?
Disastrous and catastrophic. Even our entire brand identity rests on ethical sourcing. Consumers trust us precisely because we make and keep these promises. If the public learned we sold cakes with coca tied to fraudulent, unethical practices, we would lose customers' trust overnight. We'd face boycotts, press scandals, possible legal action for misrepresentation. It would destroy the brand we have spent years building. We could not risk that. That's why we had no choice but to terminate the contract and protect our integrity. Thank you.
Thank you so much, Mr. Arbitrator. I shall leave the time to the arbitration tribunal.
Yeah. Examination witness is over, isn't it?
Yes.
With your permission, Mr. Arbitrator, I would now like to begin cross-examination of the witness.
Yeah. Go on.
So, could you once more repeat your name and your position in this company?
Yes, my
Okay,
name is
Could you
Adi Praseyu. I am the head of purchasing at Nusantara Cakes, Indonesia.
okay? So, Mr. Adi, I would like to ask you before the Ghana certification fraud, it
Sorry,
came to
sir, an
light.
objection. Please refer to the witness as Miss Adi, not Mr. Adi.
All right, Ms. Adi, before the Ghana certification scheme came to light, did you have any complaints with the cakes provided? Ms. Adi, yes or no?
No.
No, you did not. You were content that the cakes were of perfect quality and were of a perfect taste. That's right.
Yes,
On the
because
10th
the
of February,
police the quality of the products to us because
yes,
we
Miss
knew
Adi,
that.
on the 10th of February, the claimants acknowledged that the cakes may not fully follow your ethical sourcing standards. Is that correct, Miss Adi?
Yes, can you please repeat the question again? You are not audible
sure.
clearly.
Yeah, well, Mr.
on
Counsel,
the-
you be precise on the question. Be precise. Otherwise, the witness cannot understand you. Yes.
Yes, sir, arbitrator. Much obliged. Ms. Adi, on the 10th of February, the claimants acknowledged that the cakes may not fully follow your ethical sourcing standards. Is that correct, Ms. Adi?
Yes, it was after a lot of time we asked them.
Okay. Ms. Adi, you did not sell the 600,000 cakes, correct?
Yes.
Yes. Can you tell me, Ms. Adi, putting 600,000 cakes to waste, how does that protect the environment or society in any way, Ms. Adi? Can you tell me?
Sorry, objection.
Yes or no?
Relevancy of the question.
No, we can't understand the
question
question. What is the question? You do it again.
Yes, sir. Yes, sir. Arbitrator, much obliged. Ms. Adi, could you tell me what is the how can you justify putting 600,000 cakes to waste? Does it protect the environment or society in any way, Ms. Adi?
No, this question is not good.
Yes,
Because it will
Not
destroy our brand, and that
not
is
relevant. You are not answered. Yes. Next.
Much obliged, Your Yes, Miss Adi. Surely every seller in Indonesia does not follow your sustainability standards. Could you not have sold your 600,000 cakes to other sellers who do not have the same sustainability standards to mitigate your losses, Ms. Adi?
Sorry, sir. Objection regarding the relevancy of this question as well.
Sir, this question, much obliged, sir, this question is related to the mitigation principle.
No, we fail to understand what is the content of your question.
Sir, arbitrator, this question relates to the mitigation principle. Can I be allowed to ask?
Yeah, we will ask in short manner.
Yes. So, Ms. Adi, surely not every seller in Indonesia follows your sustainability standards, right? Yes or no, Ms. Adi?
Yes, but to the another company we do contract. We will always tell them our regulation about sustainability, and we only take the sustainability products, and we have already
You have not answered my question,
mentioned
Ms. Adi.
that
You have
to
not
our
answered my
claimant
question.
also.
Ms. Adi, you have not answered my question. I have asked you, does every cake seller in Indonesia follow your sustainability standards? Are your sustainability standards?
But with whom we do contract, we always follow our rules and regulations. I can
I'm
answer
asking
that.
about other sellers in Indonesia. They don't follow your sustainability
Objection, sir.
standards, right?
Yes, because that's our
Yes.
regulations, not other companies'
Yes, exactly.
regulations.
You have admitted these regulations are your regulations, not the regulations of other sellers, right? So now let me proceed with my following question. Ms. Adi, when you saw that the cakes were not following your standards, to mitigate your losses, you could have sold them off to any other seller or to other sellers in order to mitigate your losses. Isn't that correct, Ms. Adi?
Objections or relevancy.
That is relevant to the mitigation principle.
We could not sell such cakes as they are against our brand identity, and we stand for that.
Miss Adi, you have said the cakes were of perfect, good quality and good taste, that you did not have any issue with them priorly. And you have said that you cannot sell these cakes because they do not comply with your standards. There is nothing to suggest that other sellers could not sell them, right? You could have sold these cakes to other sellers and they could have sold it. You could have mitigated your losses, Ms. Adi. Isn't that correct?
Because it will diminish our brand identity. So it's not our duty, because that's your company's fault, not ours. So we should not do that for you.
Objection, sir. Council is badgering.
It's all right. Proceed on.
Yes. Ms. Adi, your reputation would not be damaged because you would be selling it to other sellers. They would not. You are not selling the cakes to the consumers. You are simply putting off a burden, right? You are selling perfect quality cakes to companies that do not have your standards of sustainability. They could have sold it. They could have sold it, and you could have mitigated your losses, Ms. Adi. My question to you would be that you chose to not
let me answer that.
cake,
you are not
correct?
letting me to answer, Council.
Yes.
Okay.
Ms. Adi.
We did sell that cakes because scandals were already out. So how could we sell the cakes that were not good enough and marketing was not good there?
Ms. Adi, these cakes, as you have
no one will buy that cake because many scandals, misrepresentations were already out. So how can a person buy a cake which have a lot of scandals?
Ms. Adi, you are misleading this tribunal. There were no scandals involved regarding our case.
And also that goes against our internal policy. We could not breach that.
Ms. Adi, this arbitral tribunal, the contract, it is governed by the laws of Bangladesh. The laws of Bangladesh state that you have the duty to mitigate your losses. And Ms. Adi, on the exclusive supply agreement that you signed, it clearly puts the exclusive agreement as well as the laws of Bangladesh above your own business policy, your own business philosophy, and code of conduct.
Council, ask question. You are giving.
Why you are stating? You ask question. You are making a statement.
Ms. Adi, I would much obliged, Mr. Abi.
Our main motto of the company is sustainability, and we cannot go against it.
Ms.
So please,
Honorable Chairman, I have a question.
Yeah, sure. You put it.
Yeah, Mr. Adis, you know, the option could have been, rather than terminating the contract, you simply could have been made a price adjustment, price deduction. I mean, what triggered you to terminate the contract rather than doing a price deduction? So, I mean, isn't it true that the deviation was a small, not a fundamental? And what step you have taken while communicating to your customer about the breach? You know, have you rendered any apology and how this has happened and is not going to happen more?
Okay, let me explain that. After the scam were exposed on 19th January, we emailed them asking for clarification on 27th January. However, they failed to provide us with any clarification. That's why we conducted an internal audit. After we conducted internal audit, they confirmed on 10th February that they used coca from Ghana. That's why we had to terminate the contracts, as we could not move forward with the brand that is associated with scandals in sustainability. And why we did that is the breach was fundamental, so we did that.
So you said you didn't get enough information, and how do you decide the breach was fundamental? You know, so.
1 minute is left.
Yeah, one question from the chairman. Yeah, these 600 pieces of
Okay. After we signed the agreement, the core responsibility to make sure the goods are sustainable was on the claimants. After getting promises of sustainability, we relied on their products as a whole. As a whole, contract was based on trust and one core obligations for the claimant, that is sustainability. That's why we did that.
Yes, one question from the tribunal. You see, the 600,000 cake have already been sold by you before the scam came in. But you have not paid for that one. Later, when you found that there is a scam regarding the Ghana certification, you take the opportunity of raising objection to the claimant not to pay them, isn't it?
To mitigate loss.
No, we paid for the cake we sold.
You have already paid. You have already paid. You have not paid. That's the due claim of the claimant. You have not paid for 600,000 cakes, but you have sold it. That's a past and closed transaction that have been sold in the market. Now, when the scam regarding Ghana certification came in, then only you have raised the objection, isn't it?
Yes.
Previously, have not raised any objection.
Yes, because their products were very polished and seems very luxury.
But you have sold that entire 600,000 cake to the market without any objection from your customers. Is it correct? Is that correct?
The scandal broke out. We sold the products, but after the scandals were out in the media, we stopped to sell that.
For the future consignment. But those consignment you have already received and sold it to the market, that didn't affect anyway.
Another issue is that, consumer assessment need to be done and in Indonesian market, how many consumer is really serious about sustainable product. Okay, and if there are not many, then it cannot be a fundamental breach. Okay, so there will be, you need to do that.
Yes, you proceed on. Any more question by
Honorable Chairman, I have a question.
Yeah, sure.
Ms. Adi, can you say you are in connection with purchase at the time of agreement and receiving first shipment? Did you scrutinize the certificate in question, sustainability certificate?
No, they did not. The 600,000 cake have been sold to the market without any objection from the customers.
Another question, Ms. Adi. It means that you admitted and recognized your long silence. They supplied these cakes since long years, for long 2 years. Before this media flourishment, you never asked any question. So you even did not scrutinize the earlier certificates. So I can ask you, on good faith, the distributor, the claimant, supplied those goods to you on good faith?
Because we relied on their products as the whole, and contract was based on trust and one core obligation for the claimants, that is sustainability. And we sold the cakes, but after the scandals were out, we did not sell any cakes cakes and we did not pay for that.
Fine, fine. That may be for any future consignment, but not for the the consignment you have already received and sold it in the market. You cannot retain the price of it. 600,000 cake that have been sold, you have not paid for it. Yeah. Yes, you go on. The question. Any more question from the claimant side?
Miss Adi,
No.
another question.
Okay.
Sorry. Go on.
Proceed.
Miss Adi, have you got any written complaint from your customers? And did you show it as exhibit?
Yes, sir.
Any complaint from the customers?
Yes.
Who is what is the exhibit number? Did you produce that complaint?
Yes, termination exhibit.
Again, exhibit number. Can you say?
It is named as termination exhibit.
Termination, another thing. Termination, another thing. I ask you, any complaint?
Luke's Cafe Group.
Is it a written complaint?
Yes, it is written documentation.
Annexer number? Exhibit number?
It is named as termination exhibit. It does not have a number.
It does not have a number. Thank you. Go ahead. Thank you. Go ahead. Ask question from the claimant side.
There are no more questions. Arbitrator, much obliged.
The claimant may proceed with their arguments and submissions.
May it please the court. My name is Imam Asif Yusuf. I would apologies, the arbitral tribunal. My name is Imam Asif Yusuf. I would like permission to move on with the substantive arguments on behalf of the claimants, if the arbitral tribunal gives me permission.
Please proceed.
Thank you, Mr. Arbitrator. From the very beginning, during the opening statement, my co-counsel has stated that we are filing this arbitration on 3 grounds. First of all, we assert that there are no damages that are payable to the respondent for the alleged breaches that they have talked about. Furthermore, we contend that the claimant here has actually acted in good faith throughout the contract. And lastly, we will address the question that whether the respondent is obligated to pay for the delivered goods and compensate the claimant. Now, firstly, I would like to start off with the first substantive argument ground, that is that the respondents are not eligible for any sort of damages. First of all, I would like to cite Section 73 of the Contract Act of 1872, which states that all losses which naturally arose in usual course of things from such breach or which the parties knew when they made the contract to be likely to result from the breach of it, but no losses for remote or indirect damage are mentioned in the Contract Act. I would like to point out to the arbitral tribunal that the exclusive supply agreement clearly states in Article 18 that the governing law, the substantive governing law in this agreement is governed by the laws of Bangladesh, and we will proceed with the whether the damages are payable by the respondents by accordingly with the laws of Bangladesh. Now, and in question of their while citing Article 20 of the agreement, we see that there is an order of precedence. In case of inconsistencies among contract documents, the order of precedence shall be the exclusive supply agreement is the first and foremost document that we must refer to, and their buyer's code of conduct and general business philosophy is the last document that shall be considered. Now, moving on, I would like to show this tribunal that the damages that they are claiming, that the alleged damages that they are claiming is not directly from the actual alleged breach. It is remote and indirect. The long-established common law principles are of expectation of asking for damages is expectation interest or reliance interest or restitution interest. Here, in this case, neither expectation or reliance is applicable in this scenario. The only part is restitution, where they can stop us from actually getting any sort of advantage from breaching the contract, whereas there is no factual proof that we're being in any way we're losing business. We are not getting paid for the overdue 600,000 cakes that they have already admitted that they have sold, and we are entitled to at least the production cost, the cost on our side of producing and delivering, the what they could do, as suggested by the Honorable Tribunal, is that they could have negotiated a price cut. Now, furthermore, the losses that the respondent has reportedly suffered is not direct result of any breach of the contract by the claimant. Negating damages based on expectation and reliance is that they had the full freedom to sell the 600,000 cakes, and they did so. And now, not actually giving us the at least the production cost of the cakes is just bad business practice, and what they're claiming as their ethical standards, their sustainability standards, is just a whole lot of just contradictory statements. Now, furthermore, what my co-counsel was trying to reiterate that they did not try to mitigate their harm, as they have said that they once that they got the knowledge of the Ghana scam, they immediately suspended the contract. When asked for a clarification, we did clarify that it was a small batch of the cocoa that was used for the cakes. So after that, instead of mitigating the damages, instead of responding positively to the negotiations, they terminated the contract. They did not try to mitigate any sort of the situation, because a long-drawn process of a new contract would be disadvantageous for them and us. Now, furthermore, the point that my co-counsel, Mr. Naeem Haider, was trying to emphasize that the respondent is actually in breach of the confidentiality. Now, the witnesses have stated that the public expose has linked our company to the Ghana scam, but whereas nothing in the BIAC case number 5, if the arbitral tribunal would look at BIAC case number 5, page number 1, last paragraph, this understanding changed on 19th January 2024, when a televised expose on the Bangladesh State News Network reported serious fraud in Ghana's Sustainable Agriculture Certification Scheme. There is no mention of our company being linked to the public expose, and therefore, thereafter, all the communications that took place regarding the expose, regarding the non-conforming cocoa, was private through email. So how could they claim that they have had public reputation damage where they cannot show anything? Their own Facebook screenshot seems to be falsified, because the certain technical aspects, like the reaction count of the Facebook, it says 1169K, emphasizing that it is a 1169,000 reaction, whereas the Facebook interface would show that it was a 1.1 million reactions to that. We had the only exhibit they can show is the Facebook screenshot that the customers are complaining that the Nusantara Cakes has fraudulently sold cakes. But again, there is no mention of our company, Sweet Delights, being associated with the Ghana scam. Therefore, it would not have been public knowledge, and therefore the respondents claim that they had not made it public, that they had not breached confidentiality. Confidentiality is false. Whereas if we look at the email they were sent from Lux, it clearly states that they had informed them on 10th February about the non-conformity. And thus it clearly shows that they are the ones who breached confidentiality. If I may take you to the contract, Article 19, which governs confidentiality. All non-public information exchanged in connection with this agreement shall remain confidential unless it is in the public domain, which I have already mentioned to the arbitral tribunal that it was not in the public domain. Furthermore, disclosure is required by law or regulatory authority. There were no such disclosure required. And lastly, the only way left was they would need to get a written consent from us for any sort of disclosure provided to any other third party. But here, they informed Lux on 10th February without taking any sort of written consent from us. That is clearly a breach of confidentiality on their part, and therefore they should be held liable for the, as stated in Article 19.2, a breach of confidentiality will result in liquidated damages of US $500,000 payable by the breaching party, which the respondent is. Now, furthermore, this breach, let us quantify if, as the respondent has already admitted that they have sold off the 600,000 cakes, the production cost for the 600,000 cakes was $2.1 for every cake, and therefore our profit on those cakes would only be a mere $180,000. And if it is reduced from the $500,000 confidentiality liquidated damages, we are still liable. We are still owed $320,000. And therefore, the respondents' claim that we are not entitled to any sort of damages is completely baseless. They could not show how, from the alleged breach, there was a direct damage, and the only damages that they can show are not linked to us. They are too remote, they're too indirect, whereas we had no control over it. We were falsified. We were also falsified by a third-party fraudulent action. Now, after this, I would like to go on to emphasize that the claimant has acted in good faith throughout the contract. Section 37, subsection 3 of the Sale of Goods Act 1930 of Bangladesh states where the seller delivers to the buyer the goods he contracted to sell mixed with goods of different description not included in the contract, the buyer may accept the goods which are in accordance with the contract and reject the rest, or may reject the whole. Subsection 4 adds that the provision of this section are subject to any usage of trade, special agreement, or course of dealing between the parties.
1 minute is left.
We acknowledge this. I would like to ask permission from the tribunal to get an additional minute to wrap up my submissions, if Mr. Arbitrator requires.
I have one question to regarding the their breach, their allegation of breach. So what is your legal submission on that? So
my humble submission, Mr. Arbitrator, is that
based on the local Sales of Goods Act, and then by the contract, CISG has been made applicable.
Yes.
And then also UNIDOT also made applicable. So based on all three, in reply to the breach, allegation of breach, fundamental breach, what is your submission?
Mr. Arbitrator, we humbly submit that the small batch of cocoa that went to the respondents, or went to the respondents' cake, does not contain a fundamental breach on our part. Furthermore, the fact that we were not associated with the Ghana scheme in any way, and it was a third-party fraudulent action, and that
which section you're relying on the Sales of Goods Act for saying that it is not fundamental breach?
A moment, Mr. Arbitrator.
Yes.
Yes.
Huh?
If I could have a moment, Mr. Arbitrator.
Shouldn't you be rather relying on substantial compliance under Section 37?
Yes, Mr. Arbitrator.
That not covered in your argument.
The claimant relies on Section 73 of the Contract Act 1872, which limits damages to losses that naturally arise from the breach and excludes remote or indirect losses. This principle.
Yeah, that question comes only when there is losses and other things. Do you admit that there is losses of the respondent from selling this 600,000 cakes?
No, Mr. Arbitrator, as I have already mentioned,
37 will be applied when there is admitted loss.
Exactly, Mr. Arbitrator. As we have already emphasized that the respondent has sold off the 600,000 cakes. They have not sustained any sort of damage directly from that alleged breach.
Already you have an admission. One of your, you have made
in the statement of claim, you have an admission.
Yes, yes, Mr. Arbitrator, we do admit that there was a small portion of cocoa that went into their cakes, but we also would like to point out that there are several articles of the CISG and the Android principles that state that if the seller has acted in good faith upon knowledge of the breach, the damages should not be considered a fundamental breach. Therefore, as I would like to point out that the corresponding dates, the knowledge, the email from Nusantara and our immediate response does exhibit that we acted in good faith. We did not produce any more cakes to them that came from the fraudulent supplier once we got to know. And furthermore, the one moment, Mr. Arbitrator. The Article 16.1 and 16.2 of the agreement obliges the respondent to pay $2.4 per cake, totaling to $1,440,000 for USD for the 600,000 cakes, which they have not paid, and they have admitted they have already sold off. They have not shown any sort of actual direct damage due to the alleged breach, and which we do not acknowledge as a fundamental breach, because the claimant has always acted in good faith. And under Section 55 and Section 73 of the Bangladeshi Contract Act 1872 and CISG Article 53, failure to pay for accepted goods is a breach. In Shonali Bank versus the MD Abdul Mannan, the seller was entitled to the full contract price of the breach. And so we are using that precedent to ask for that alleged the compensation of 1.4 million. And furthermore, as I stated before, the breach of confidentiality and liquidated damages of 500,000. And if I may take the tribunal's attention towards CISG Article the CISG Article 39.1 and 2, the respondent cites media reports, not any contractual evidence, and gave no timely notice of the non-conformity required by the said articles. There is no proof of any defect at delivery, and CISG Article 62 allows the seller to demand payments unless pursuing inconsistent remedies. Here, the claimant has from day one pursued consistent payments of the 600,000 cakes and the liquidated damages. Article 3.3 bars unilateral price changes, and the respondent's attempted set-off has no contractual basis. Under BIAC, the 10 February 2024 investigation found only minor third-party sourcing issues, not affecting quality. The claimant disclosed this in good faith. The claimant disclosed this immediately after getting to know, and showing cakes still met contractual standards as per their contracts, as per they stated that it needs to have valid certifications, which at the time we did know. which at the time we did know that the certifications were valid and not from a fraudulent source. And therefore, the respondents claim that we are to blame for the third-party fraudulent certifications is absurd, because we ourselves were also fraudulently misguided by the Ghana scheme. Therefore, we pray to this arbitral tribunal that the claimant seeks interest on the late payments under Section 34 of the Arbitration Act 2001, CISG Article 78, and Android Article 7.4.9. As affirmed in BPDB versus Summit, interest is owed from the last delivery until full payment, and they were supposed to pay within 60 days. And this arbitral tribunal, we are currently on 12th July of 2025, and our last shipment to them was on 27th of January. So it has been well over 60 business days, and the respondent has not paid the overdue amount from which we seek interest. So therefore, if I may be allowed to read my prayers to the arbitral tribunal. As a result, the claimant respectfully requests the arbitral tribunal to issue an award declaring that no damages are payable to the respondents, declaring that the claimant has acted in good faith, ordering the respondent to pay for the delivered goods and compensate the claimants, and ordering respondent to bear the arbitration fees.
I have a question.
Yes, Mr. Arbitrator.
You answer shortly.
Yes, Mr. Arbitrator.
You prayed for US dollar on 440000
yes.
For delivered cakes.
Yes, Mr.
Behind this claim, you have a ground that you have admittedly you have delivered those cakes to your to the respondent. It is admitted that
Yes,
you have delivered it.
Yes,
but
Mr.
second prayer, liquidated damage for breach of confidentiality,
Yes, Mr.
US dollar
500,000.
500,000 US dollars. On what basis you asked these US dollars? On what basis? And is there any audit report or any documentation have you submitted before the court basis of this claim?
Mr. Arbitrator, if I may lead you to the email that the respondents have sent as an exhibit with Lux Cafe, where they clearly state that they have informed Lux Cafe on 10th February, the very date we told them about the small portion of the cocoa that was supplied. They conferred that knowledge to a third party, Lux Cafe. And there is nothing in the facts that suggests that this non-conformity was a public knowledge. The non-conformity of our cakes, the small portion, was public knowledge. And the governing contract, if I may take Mr. Arbitrator to the Article 19 of the exclusive supply agreement, which states that if it is not a public knowledge, it can only be disclosed by written consent from both parties. We did not give any such written consent, and the respondent cannot show any such written consent from our side to show that they could breach the confidentiality. And furthermore, it is in the contract itself, Article 19.2, which states that a breach of confidentiality will result in liquidated damages of 500,000 US dollars payable by the breaching party, which the respondent has breached.
Is it a matter of confidentiality?
Yes, Mr. Arbitrator. Every email was private. Every communication between us was private. Them disclosing the fact that some of our cakes may have been non-conforming with their standards to a third party named Lux Cafe is a clear breach of confidentiality, whereas we have not given them any sort of written consent to do that.
Thank you. Go ahead.
Much obliged, Mr. Arbitrator. I am respectfully, I am done with my submissions. If the tribunal has no further questions, I would like to resign from the.
Yeah, sure.
Much obliged, Mr. Arbitrator.
Yes, next.
Good afternoon, members of the tribunal. I am Shmiti Saputa, as a closing counsel on behalf of the respondent.
You are Smriti Sapkota.
Smriti Saputa.
Yeah.
Yeah.
This is submission from
closing
from respondent.
Yes.
From the respondent.
Yes, sir.
Smriti is
Honorable Tribunal, shall I commence?
1 minute.
Okay.
Quota. You start.
Okay. So also I would like to prior inform the tribunal that all the exhibits I will be citing in my argument are the exhibits submitted from the side of the respondent. Shall I commence now?
Sure.
Okay. The sanctity of contract is the foundation of commerce. Where promises are broken, markets unravel. Honorable Tribunal, we appear before you today not for any commercial advantage, but to defend a foundational principle of international business, the sanctity of contract. Sweet Delights Limited did not merely promise to supply cakes. They entered into a binding agreement that made one element absolutely non-negotiable, that all cocoa must be ethically and sustainably sourced and verifiably so. This wasn't an aspirational clause, it was a core condition, clearly defined in clause 2.2 of the exclusive supply agreement, reiterated in the tender documents and underscored throughout the supplier code of conduct, which Sweet Delights accepted without any reservation. The obligation was not about quantity or flavor, it was about integrity. Clause 2.1.1 of the Code of Conduct made it very clear that sustainability is non-negotiable. Clause 2.1.3 of the Code of Conduct removed any doubt stating that a basic breach occurs when sustainability standards are not met. On 10th of the February 2024, Sweet Delights admitted that the cocoa they used did not meet these standards. No valid certification, no verifiable source, and no compliance. This was a breach not just of paper, but of principle. A breach not just of process, but of trust. The kind of breach that does not just disrupt the business, it undermines the very foundation of a brand. Under Section 73 of the Contract Act 1872, when a contract is breached, the aggrieved party is entitled to compensation for losses arising naturally from such breach. Here, the supply of unsustainable cocoa violated an express term justifying full remedial consequences under Bangladeshi law. Under Underwrite Principle, Article 5.1.62, when the purpose and nature of a contract clearly demand a specific high-performance standard, as in sustainability-based supply agreements, failure to meet that standard constitutes non-performance. Sweet Delight's failure was not an innocent omission. It was a fundamental breach of the very condition that anchored our commercial relationship. They now invoke good faith, but honorable members, good faith is not a substitute for non-performance. As Underwrite Principles, Article 5.1.4 confirms. A party's intent is no defense when they have failed to deliver results they clearly promised. Commercial obligations are measured not by sentiment but by outcome. Promises must be kept, not just meant. If mere intention could excuse failure, then contracts would collapse into hopeful suggestions, void of accountability. The claimant cannot rewrite the contract's core duty by appealing to moral gestures. They undertook a binding results-based obligation and failed. And the fallout was not hypothetical. It was immediate and devastating. After the Ghana cocoa scandal broke in media on 23rd of January 2024, Nusantara Cakes was directly implicated. On 27th of January, the editorial From Trusted to Tarnished triggered viral backlash under hashtags like Nusantara Exposed, retail partner terminated the contracts, severe loss of consumer trust and loyalty for Nusantara Cakes, and a sharp decline in sales. These are not speculative harms. They are well documented and entirely foreseeable given the centrality of sustainability to our brand. For example, Exhibit 1. One, which is an internal audit summary, shows that Sweet Delights failed to provide credible certification during our compliance review following the media reports. Then, the termination exhibit reveals how Luke's Cafe Group, a major client, cancelled its contract with us, citing reputational risk and betrayal of our ethical promises. This wasn't a knee-jerk reaction. It was a strategic, values-driven withdrawal, and we lost that business solely because of the cocoa supplied by Sweet Delights. Now, let us place this dispute in a broader legal and commercial context. In today's global market, sustainability is not a luxury. It is law, it is policy and consumer expectation rolled in one. Companies are increasingly judged not just on what they sell, but on how they source, manufacture, and deliver. Contracts that embed sustainability are not only enforceable, they are essential tools of ethical commerce, which brings us to a compelling legal precedent that is 𝐕𝐧𝐭𝐞𝐫 versus Becher GmbH, which is a case of Germany. In that case, a supplier delivered goods that violated the buyer's eco standards. The court found this to be a fundamental breach because it conflicted with the buyer's core brand identity. The legal takeaway was very clear. If a supplier undermines a buyer's brand values, especially in areas like sustainability, it constitutes a breach justifying termination. Just like in Smith's work, we did not get what we contracted for. We got products that compromised our brand, exposed us to scandals, and led to contractual termination and commercial losses. And now they claim payment for cakes we could not ethically or commercially sell. But under CISG Article 35, goods must conform to the contract. These cakes did not. Ethical cocoa was a non-negotiable term and they violated it. They say we should have sold the cakes anyway, but to do so would have been to amplify the damage, more consumer backlash, deeper reputational harm. Instead, we acted responsibly. We conducted an internal audit. We even gave them a chance to justify the breach. They failed again. They accuse us of leaking information, but the media scandal broke before we made any statement, and Article 19 of our agreement permits disclosures of facts already in the public domain. The claimants now try to cover it up with due diligence, trying to pin the blame on our part. Yes, we conducted due diligence through supplier audits, documentation reviews, and verification of third-party certifications before accepting deliveries. However, when the Ghana certification was later discredited, we immediately suspended affected batches and launched an internal review demonstrating our commitment to compliance, not negligence. Due diligence is ongoing, not a one-time checkbox. Also, the CEO of Sweet Delight stated in their cross-examination, that they made conformity to sustainability as far as possible. But this is not what you say after signing a contract that is built on just one condition, that is sustainability. So the statement given by the CEO of Sweet Delights clearly shows how reckless they were to maintain sustainability that led to loss of trust in our brand, cut in retail ties, and loss of business as well. Also, I would like to address the query raised by the opening counsel of the claimant that the goods were accepted without any condition. They were accepted only because of one condition, that the claimant promised us for sustainability of the goods. This pretty much shows that the claimants are in fundamental breach of the agreement, and then they are now trying to pin the blame on our part, which is not justified in terms of fact or even the law. We therefore ask this tribunal to award us the following damages: $1.44 million for unsaleable cakes, $500,000 for brand damaged and lost trust, $500,000 for terminated client contracts, and $100,000 for compliance and audit cost, which makes a total figure of $2.54 million. Each of these figures is grounded in real-world evidence, documented fallout, and contractual causation. In conclusion, Sweet Delights fundamentally breached the contract by failing to supply ethically sourced cocoa. The breach caused serious, foreseeable, and documented harm. Our decision to terminate the contract was lawful, necessary, and proportionate. Their defenses, good faith, remoteness, and entitlement to payment failed both legally and factually. We ask this tribunal to honor that truth and and declare a fundamental breach occurred, uphold our right to terminate under CISG and Underwood principles, award us a damages of 2.54 million and dismiss all the counterclaims made by the claimant and award us any cost and any other reliefs deemed just by the tribunal. As Lord Dennings once declared, contracts are not mere formalities. They are solemn promises to be honored in both text and truth. We trust this tribunal will issue a ruling that defends contractual truth, protects ethical commerce, and delivers fair and principled justice. Thank you. We rest our case here.
I have a question. If you permit, Honorable Chairman.
Sure. You go. Procedure.
We are to look into the tender, public tender invitation document, which is admitted by both the parties. Section 5A, dispute resolution, wherein it clearly provides any disputes arising out of or in connection with the contract shall be resolved through arbitration in accordance with the BIAC Arbitration Rules 2019.
Yes, sir.
I asked the respondent, it is admitted, this tender invitation, invited by your company, Nusantara. And if so, any dispute arising out of any dispute, if so, have you any legal right and authority to terminate the contract without the award given by any arbitral tribunal? Does it mean that you have taken the laws in your own hands by terminating the contract without the award of any arbitral tribunal?
Yes. The dispute resolution clause is set in order to resolve any disputes arising. But let me draw the attention of the Honorable Tribunal to Article 17 of the Exclusive Supply Agreement, which states in the first point that the agreement can be terminated in the event of a material breach of contractual obligations not remedied within 13 days of written notice. As we sent the email to them, they failed to reply us through emails. After we conducted the internal audit summary, they only admitted it after we found it out through internal audit summary that they used the scandalous cocoa which was sourced from Ghana, and under the agreement we are allowed it to terminate the contract, and after the termination to resolve the dispute that was arising for the cakes or anything else, we have come to the tribunal to address such disputes, but only for the termination we were allowed to terminate the contract on the basis of Article 17. That's why we did so. I hope I addressed your question, but if not, I am willing to answer further as well. Sorry.
Thanks, I have no question.
Thank you, sir. Any other questions from any other members of the tribunal?
I have a question. So you're relying on Contract Act. Okay, but it's a sales of goods. Clearly, under Bangladesh law, Sales of Goods Act apply. And if nothing is there, only then Contract Act will be applicable. Okay, so which section, is there any section you want to refer from the Sales of Goods Act, claiming that it is a fundamental breach and you have a right to reject the goods?
Yes, I would like to cite Section 35 of the CISG, which states that goods must conform to the contract, and in our contract, the goods must have been must contain the ethically sourced cocoa, as it is also mentioned.
Is it CISG's is a contract specifically mentioned that CISG replaced Sales of Goods Act? Is it mentioned in the contract?
In the contract, the governing law is provided is...
That's Bangladesh law.
Yes.
And then CISG also made applicable.
Yes.
Under Bangladesh law, Sales of Goods Act fits in. And then CISG is basically who are similar matter they're dealing with. So what the contract clearly says, is the Sales of Goods Act apply or the CISG will apply?
we are provided with hierarchy of the applicable laws under Article 20, and also it is explicitly mentioned under Article 18 that it is governed by CISG, and also for the issues not covered by CISG, it is governed by underwrite principles. So as it is mentioned in the fact sheet, in fact it is one of the binding documents we get.
Okay, I think you can refer from CISG. So what was the section you're mentioning?
I'm referring to section 35, article 35 or section 35, which says that courts must conform to the contract. These cakes did not, and then it shows a fundamental breach on the part of the claimants.
So what section provides you the right to reject under CISG? You have rejected the good. You're saying termination, fundamental breach. You're relying on a contractual term, and then again also rely on CISG. Okay, so I mean, you must have to justify to the tribunal that you have a right to reject because there is a fundamental breach. And the other side's argument should be based on CISG that they have performed a substantial performance. And you don't have right to reject, but only have right to deduct, from the claim, from the amount.
Yes. Sir, arbitrator, I properly get your question now. So I'll be citing Article 35 for lack of conformity, and also it is stated that if the standards set by in any contracts are not met, the buyer has a right to reject the goods as non-conforming.
Okay, thank you.
Thank you, sir, arbitrator.
Yes. So the parties' work have been ended. Yes. Now it is the yes. Now it is the job. Yeah.
Yes,
Yeah.
sir. So both of the team has submitted their submission. Now I would
Right.
request to all of the respected arbitrators to submit the
Right.
score sheet via email or WhatsApp. And in the
Yeah.
meanwhile, we will watch a short video of BIAC.
Yes. Okay. Fine. We'll send it by 10 minutes. Inshallah.
Okay, sir.
Yeah. We'll send it by 10 minutes through WhatsApp. I'll send it through WhatsApp, the scanned copy. Yes.
Okay, sir.
The learned arbitrators, you please send your copies to the BIAC. Either by email or by WhatsApp. Make a scanned copy and send it through WhatsApp.
Sure, sir.
Yes.
Yeah.
Yes. Honorable.
এই ওদেরকে পাঠাইতে হবে স্পোর্টটা এদিকে আসেন তো কই পাঠায় নাই?
পাঠাই দিচ্ছি তো স্যার, ইমেলে 33 মিনিট আগে।
আমাকে দিছো?
আপনাকে আমি আপনাকে ইমেলে দিচ্ছি, ওদেরকে হোয়াটসঅ্যাপে দিতে হবে। এই সাবজেক্টটা স্যার হচ্ছে ডকুমেন্ট ফ্রম নোম্যান্স রুল আমার ইমেলে সাবজেক্ট। পুরোটা মানে আমাদের যেটা ডিজিটাল ওরা যদি একটু কম্পারেটিভ অ্যানালিসিস ওরা আমরা কি থেকে কি করতেছি এটা পুরোটা না, জাস্ট আমাদের জিনিসগুলো। এটা এটা ইয়াতেই ছিল, এটা মূল সেকশনটাই, এটা মূল সেকশনটা ইডি লস বিধিতে যেটা আছে ওইটাই, আর আমাদের কমেন্ট আছে আমাদের comment।
এটা আনার তো দরকার নেই, আমরা অসচ্ছলটা বাদ দেওয়ার কারণ ডিফারেন্ট।
আমরা অসচ্ছল বলাতে ওরা অ্যাড করছে, আদার্স কমেন্টে আপাতত এটা অস্বচ্ছতা আছে। এখন যদি আমরা এটাকে
Yes, I'm here. Anybody here? Yes,
So,
I've sent
we
the
all
I've
are,
sent the result sheet. I've sent the result sheet through email.
yes, sir, we have received it and now we all are calculating it.
Yeah, thank you. Thank you.
Good evening, everyone. We have
Yes.
calculated all the scores and which will be sent to our chairperson. But before that, I would request to everyone to turn their video on so that we can take a group picture.
Have you sent it?
Yes, sir. My team is sending it.
Sending,
So
not
it
yet.
will be sent to you.
Through email.
Yes, sir.
Yeah.
So participants, please turn on your camera so that we can take a group photo.
Yes. I do not know about the other learned arbitrators, but I felt very difficult to give points because everyone deserving 100 points. So it's very difficult to differentiate who should be given lesser point.
I think we still have some participants not opening their video. Please open your
Not
video so that
everybody,
we can have
somebody
a
has done,
photograph.
but not everybody, not yet.
Participants, please open your video.
So we think all of are present here.
I can't see everyone on the screen. I think there are still few not on the screen.
Not yet open their video. Perhaps Mr. Rumi Ali's phone have been hacked.
Yes, sir.
Suppose it has been hacked.
Yes.
The Rumi Ali's phone.
Just asking for 40,000, not much.
40,000 is asking.
Okay, sir, everyone is here. Let's take a picture. Everyone smile, please.
Yes. I must appreciate the team from Kathmandu because all of them are very bright future arbitrator.
Absolutely.
They will definitely shine in their law practice. And also the participant from London School of Law, legal studies, South. All these people, the new generation is very prospective. They are very
absolutely.
Yes.
The arguments, the cross arguments, the examinations.
Yeah. Very nicely they have submitted. Very nicely they have submitted.
And the choice of words. And
yes. 𝐷𝐵 𝐺𝐻𝐾, he's a very intelligent witness. Confident and intelligent witness.
Sir, can you request our today's honorable chairperson to say a few comments to all the participants?
Yeah, I request all the participants to open their video, but I have not received the result yet.
Sir, the email has been sent.
I have not yet received.
Send it on WhatsApp as well, Sohana.
Yes. Participant, have you sent it through WhatsApp also?
No, sir. Should I?
I'm not getting the BIAC's WhatsApp number, but if you can send the result sheet to my WhatsApp also.
Yes, sir.
Sir, WhatsApp number is on the result sheet. WhatsApp number.
Yes, WhatsApp, but in my phone I'm not getting the WhatsApp icon for BIAC.
Oh, sorry. Sorry.
Got it.
Okay, sir. So I think, sir, we can have some comments from you and as well as other honorable administrators.
Yes, all the participants are on the screen. Everybody are on the screen. Yes. So Alisha Tripathi. Yes, 𝐷𝐵 𝐺𝐻𝐾. Then another from Kathmandu. Who? Another from Kathmandu.
Siddharth or Pushpika?
Yeah, he's not in the screen.
Sriti, you were there, yes.
Yes.
𝐷𝐵 𝐺𝐻𝐾.
Yes, Sriti
I'm also here, sir.
Subkota and Siddhartha Krishna. Yes.
Yes, sir.
And from London School of Legal Studies, they are
Nafisa
Zahra Mahlul Kader, Nafisa Binte Burhan, Aisha MM Asif, and last one is Naeem Haider. All of you have done a very excellent job in this remote international competition. All of you have done a very excellent performance. At least so far, I have seen or I have presided over the international arbitration moot competition. Yet, one has to win and one has to lose. No loss. That is a runners-up. Yeah. So I'll ask the London School of Legal Studies to be runner-up. London School of Legal Studies is runners-up, and the Kathmandu
University.
Kathmandu University School of Law, Nepal is the winner. Yeah. Is the winner. We are really very pleased. A Zoom platform for the international moot arbitration competition, fifth BIAC International Interuniversity Arbitration Contest 2024, and it is our great pleasure, my great pleasure, to preside over this session, and also I like to request my co-arbitrator to say something. Yes, Mr. Farooq Rahman.
Thank you, sir, for announcing the results. It was definitely very challenging for us. But overall, we think there is a scope for improvement for both teams, okay, particularly with the level of research on law seems to be not very strong. And we have asked specific question. We didn't receive any concrete response. I mean, and it is very easy to make submission which is based on your preparations, but very difficult to deal with the query from the tribunal. So that is also something similar hurdle we face when Abdur Rahman sir was the judge, you know. So we always plan to make our submission as it is, but I mean, your level of preparations and
yes, that is for the practical life, but this is not the practical. They are preparing for practical life.
Exactly.
That you have faced in the practical life. But these people are growing people. These people are coming to the future practice. So they should be encouraged. Yes. Yeah.
Definitely. I mean, giving feedback is definitely is trying to improve their performance in future.
Right.
That was the only reason, nothing else.
Right.
And best wishes for both team. And many congratulations for the winner, and also, I mean,
the runners-up.
Also,
the runners-up. Yes.
Thank you.
My arbitrator, Mr. Abul Hussain Khan, please say something.
At first, I am grateful to BIAC, especially Mr. CEO appointed me as an arbitrator. It's a great pleasure for me. I am an arbitrator under the Honorable Chairman, who is a very intellectual person. I have seen him at the court. He dealt in arbitration matters for a long time. I had an opportunity to practice before his court, his lordship. Then I appreciate both the parties. It was very difficult to differentiate. I do not cite my marking, but I differentiate only on marks, but whom it cannot be exposed. It is a fact that we are not awarding now, but our duty is skillness, to justify the skillness of the witnesses and competitors, and we justified it. So result, what will be done, is it a practical case? Result, what will be done, it's another thing. We justified the skillness of the competitors. I think that both parties very nicely and fluently placed their cases and arguments before the arbitral tribunal, and I thanks all of the competitors. I thanks to all of the competitors. I hope that they will do better in future, and from our inquiry, they are conscious. They would be more conscious about their lackings and weakness. Thank you all.
Yes. So the final message from the chairman, all the participants, all the teams, members from Kathmandu University School of Law, take the message from this session that you people are very competent and you will shine in the legal practice in future, inshallah. So take this message from this session that everybody of you will one day come as a celebrated lawyer of Nepal. Thank you. Thanks the legal team from London School of Legal Studies from Dhaka. All of you are also very prominent, and you will also shine in your future life, inshallah. Thank you all.
So I'll take your permission to close the session with a few words. First of all, I would like to compliment all the participants from London College of Legal Studies South in Bangladesh and the Kathmandu University School of Law from Nepal. And I can tell you that from my own experience and having dealt with commercial disputes over many, many years, I was tilted like, it is a moment of, winning for one side, and it was a moment of winning for the other side. And the critical questions that came from you, sir, and also arbitrator, Mr. Farooq Rahman and Mr. Abul Hussain Khan, sometimes asking them critical questions like, was it in the contract? Was it, or what is your claim? Like, is it a claim of loss of business or claim of loss of reputation? So, these are more technical than the actual focus on the case. The legal aspects and the commercial aspects, when they intertwine with each other, we really get a different intellectual pursuit. And here, I think, both the teams have studied very well, and they have made good references. They have really made outstanding deliveries. And to that extent, I would say, sir, first of all, thank you so much, Justice Mr. Abdul Rahman, Chairman of the Tribunal today. Sometimes your interruption, this is not relevant to the case. And so, it was something very interesting and something, then the contestants, focused more on their points and arguments. So again, I would say that your guidance and your insight has definitely contributed to the intellectual capability and future pursuit of our contestants, as well as it's a learning for our BIAC teams too. So I thank you so much, sir. And arbitrator, Mr. Abdul Rahman, you also raised questions like, I would not be able to answer, perhaps, the sales contract versus.
Farooq Rahman is very critical on it.
Absolutely.
He's very critical.
I had dealt with him, sir, and it's very difficult to answer his question, although sometimes he's quiet, but, he would just pick on the right note. So, and Mr. Abul Hussain Khan, also, you had some intriguing questions.
Yes, he has made a lot of questions.
Absolutely. Where the participants, I'm sure you must have taken these as notes for your improvements in future, that, and when your presentation to the court, when your presentation to the tribunal, how you augment and how you fortify your deliberations. So with that, I would say that BIAC is very grateful to all the arbitrators, and particularly the chairman of the arbitration tribunal this evening. It was an enlightening and a very exciting evening. I was hearing all this 3.5-hour session, and I personally learned a lot, and thank you so much for that. And contestants, I'm really so happy about all of you. I must tell you by names that Nafisa bint Burhan, Zara Mehrab Kader, Muhammad Naim Haidar, Maisha Tanzim, MM Asif
Maisha Tanzim.
Right. And from Kathmandu University, Alisha Tripathi, Pushpika Thapa, Sangam Paudel. Sometimes I was confusing about, these pseudonames they were using and their own names. So, Siddharth Gimiri, Sriti Sapkota, and Divisha Karki, you were all excellent. I must say, it was a very good show. And I would be delighted, BIAC could be delighted to invite you to our next public event to take over the trophy. And it's going to happen soon. We shall be organizing more and more international contests like this. And this year, it has taken a bit of a long time. The rounds were deferred for certain reasons. But in the coming year, we would be quite strict with the dates so that our arbitrators and our program is not affected by, the slowness. So that's something that we would be looking forward to. And I would also thank Sanjida Sohana, who has taken all the pains to organize today's show. At the same time, she has been very, very attentive to, ensuring that this contest ends in a very good performance. Sanjida and your team, thank you so much for making BIAC proud of this event.
Yeah, and my thanks to BIAC also.
Thank you, sir. With this, let us end the session here today.
Sure.
And best wishes to everyone. Thank you, sir.
Thank you. Thank you, everybody. Thank you.
Thank you, sir.
Thank you, sir.
So,